My lord, may I renew, my lord? May I renew my prayer, my lord? Special deed matters. Your lordship has pleased to, my lord, express your lordship's opinion that we have approached late. My lord, point is that if your lordship passes that order, then the clients will know that they have what is there.
Please come and mention on Friday.
But I have mentioned on the
On
previous
Friday, I have
also.
changed the note. On Friday, I'm taking the mentioning matters. Mention on Friday, we'll list it.
Saturday is the date for date, my lord.
I cannot take
There
it.
is
But I have
extreme urgency,
filed, my lord, 2 weeks back, my lord. Kindly, my lord, if your lordship kindly accommodates, keeps the matter, my lord, then we can, at least prior to the date, we can say, otherwise it will be become infructuous.
Okay. List a near into Kiachin. Right.
I'm giving the slip, giving the number.
My lord, may I pardon? There is extreme urgency, my lord.
No, Arjun.
I mentioned the
not
matter, my lord.
Not appearing in the list, my lord.
The last
Sir, I cannot take like this because I have given a note. On Friday, you come and mention.
This
I
is the
can
third
no.
time I'm mentioning, my lord.
On Friday, you come and mention. There is a note given in the list. If you don't follow that, then
my lord, there is extreme urgency, my lord.
no. On Friday, I will take it up.
My lord, Friday is the last judicial day, my lord. And my lord, there is extreme urgency, my lord. 22nd is the, my lord, date of
Not
exam.
When did you file the writ petition?
My lord, it is filed in 9th. My lord, I
Ninth?
pray.
After the date. After the last date. After the closure of the application, you file the application.
Release the matter, my lord. Otherwise, the matter will be infructuous, my lord. Otherwise,
You are not
release the
understanding.
matter.
Give it. Give that. Friday the upper rakho order karo do.
Lordship,
Give your list.
similar player, Lordship. Mr. Onindol ID has mentioned. I
Madam,
just.
give the numbers.
এই যে,
Duck, number one.
last name
Lord sir, I'm for the petition.
টা-
I'm for the mother support, my
Lord,
lord.
the petitioner was appointed as an honors PG category in the concerned madrasa.
Who is for the state?
Well, the Lordship, kindly come my recommendation letter at page 42. 42. Page 42 is the recommendation letter recommended by West Bengal Madrasa Service Commission. Now, Lordship, the kindly come. In reference to the above, I am directed to state that, let's see the first paragraph, on the basis of the result of 5th SLST to 2011, on the basis of the, let's see, the exercise by the selected candidate in the counseling, the commission recommends the name of the candidate mentioned below for appointment against the regular vacancy for the post of assistant teacher, honors PG category in chemistry honors PG. Lordship, so the petitioner was appointed under honors PG category. Now, Lordship, petitioner's appointment has been duly approved. The petitioner also subsequently issued the appointment letter. Petitioner joined. Okay. That is page 46 and 47. 40, kindly come page 46 and 47 is the appointment letter and joining.
Wait. Don't take good.
Page 46 P3 is my appointment letter and page 47 is my join as per the recommendation. Now my appointment has been duly Lordship approved. That is page 48. Page 48. Now Lordship, the petitioner subsequently kindly come page 50. Submitted application through the secretary, to the headmaster, to the concerned secretary of the madrasa. Now, Lordship, for granting permission to undertake the master degree course. Now, Lordship, the concerned madrasa has adopted a resolution in my application, as per my application, page 50, and the resolution at page 52.
No, page 49 is the seeking permission. No.
Yes, page 50 is the seeking permission.
50 is the permission and this is the resolution.
Resolution, Lordship, kindly come page 52. Lordship, may I read? Lordship, the গত 2/4/2016 তারিখে থেকে ভূগোল বিষয়ে সহশিক্ষিকা বেনজির খানকে এতদিনের জন্য no, this is different. Resolution. Yes, Lordship, kindly come page 51. 4/12/13 তারিখে বিএসসি অনার্স কেমিস্ট্রি ডিগ্রি সহ পশ্চিমবঙ্গ মাদ্রাসা সার্ভিস কমিশনের সুপারিশ ক্রমে ওই মাদ্রাসায় যোগদান করেছেন। সম্প্রতি উক্ত পদটির রিটেনশন হয়েছে। এমত অবস্থায় মাদ্রাসার স্বাভাবিক কাজকর্ম পঠনপাঠনের জন্য ব্যাঘাত না ঘটতে পারে। পরের পৃষ্ঠা মাধ্যমে রসায়ন এমএসসি ডিগ্রি অর্জন করতে চান এবং উক্ত বিষয়ে তিনি কার্যকারী সমিতির অনুমোদন ঘোষণা করেছেন। ডিআই এর অনুমোদন সাপেক্ষে অনুমোদন দেয়া হলো।
Resolution page 51. Page 51.
51 is the resolution.
51 paragraph, the Dityo resolution is that.
Yes, the second resolution. Yes. Now, Lordship, kindly come the permission of the concerned district inspector school on 23rd November 2016.
That was forwarded by the committee, managing committee.
Yes, followed by the managing committee. Now, Lordship, not only the district inspector school had given the permission to the petitioner to undertake postgraduate degree, but also the West Bengal Board of Madrasa Education also permitted. The board is pleased to approve the study leave on full pay to Afsari Khatun, who is the petitioner herein. Approve assistant teacher of Hatisala Sarojini High Madrasa, HSPO Hatisala, intending to appear at MSc Part 1 examination 2017 under the distance course at Vidyasagar University for the period from such and such as per the leave rules 3D such and such, such and such, such and such. The Lordship petitioner has completed the course. Kindly come page 55, last name Afsari Khatun, aggregate Lordship. Now, Lordship, kindly come page 56, my prayer for upgrading my scale, page 56.
Yes.
This is my prayer, Lordship. Now, the concerned district inspector schools asks the secretary of the concerned madrasa to forward all these documents for granting Lordship the PG category, a PG scale, that is page 58. 1, 2, and 3, all relevant documents has been asked for. The copy of the resolution, approval, copy of the routine of classes and also practical classes allotted by the Vidyasagar University. Now, Lordship, the concerned subsequently, page 60, this is the impugned order.
So her prayer was forwarded to the district inspector of schools.
District inspector
Page 57.
Page 58, Lordship. Now, this
So
is forward-
57. 57 is the forwarding letter of the secretary
Yes, yes.
along with the necessary document.
Yes, I document.
Now the order is a
Now, subsequently, kindly come impugned order, that is page 60. In reference to the above subject, the undersigned has to inform him that the PG scale of pay may not be granted in favor of the concerned teacher of the school as per the Control and Expenditure Act Amendment 2016. Now, Lordship, kindly come the Amendment Act. The provisions is applicable in my favor. Kindly come page 62. That is, Lordship,
section
Four.
14.
section 3,
No, not section.
section 14, yes, subsection 4. In subsection 4, in subsection 3, the following subsection shall be substituted. Now, every teacher appointed in class 11, 12 shall be entitled to draw pay mean for postgraduate qualification and shall not be entitled to claim any additional increment or higher scale of pay for any qualification other than the minimum qualification specified for such post. So, Lordship, 11, 12 category I was appointed. I subsequently, this is not a separate, Lordship, the category. Now, I subsequently enhanced my degree. Lordship, I am entitled in as per the amended provision of Lordship, the section 14, subsection 4. Now, Lordship, I have handed over earlier occasion.
Mitu Murmu.
Yes, Lordship, the Mithurani Murmu. Now, Mithurani Murmu, Lordship, considering the same issue that honors category, that particular teacher was appointed. Now, subsequently, after due permission of the school authority and DI, completed the PG course. Now applied for higher scale of pay. Now, the prayer was refused. Subsequently, this Honorable High Court kindly come paragraph 9, page 5-9 of the order. That aforesaid facts have been made in situation abundantly clear that petitioner was appointed in higher secondary section of the said school, albeit with the educational qualification of the honors degree, but the post was meant for honors/PG candidates. At the same time, section 3(4) of the Act of 2016 provides when a teacher was appointed for the class 11 and 12, and he or she shall be entitled to draw pay mean for postgraduate qualification with a rider that such teacher shall not be entitled to claim any additional increment or higher scale of pay for any qualification other than the minimum qualification specified for such post. When the petitioner was appointed in the higher secondary section of the said school in terms of section 3(4), she is entitled to draw postgraduate scale of pay on acquiring such qualification in case of appointment of the petitioner on honors PG or to be treated as minimum qualification. If the petitioner would have obtained PG or any other qualification higher
Okay.
than the post graduation,
Yes, I have understood.
my lord,
This is my instruction, my lord. Second page.
You have given a copy?
No.
How do they say that it has been withdrawn when the language of the section says
Says
shall be entitled to draw pay main for postgraduate qualification? Is claiming for postgraduate. Now the court in Mithu Murmu has clarified that if it is PG, PhD or any other higher qualification, then that claim will be turned down. So far as the postgraduate is concerned, the amendment itself says that shall be entitled to draw payment for postgraduate qualification.
my lord, he made an application before the authority, my lord, page 56. It will be considered, my lord, in the light of the judgment passed by this court.
yes, I have
No, no. Appointed our application, sir.
application
Now
of
this this application can again be sent to the respondent authorities. This will futile exercise
My lord,
because that has already been rejected by the authorities.
my lord. Page 60, my lord, the authority reject his claim.
the commissioner.
Only that you see
Lord.
the T-line order stating that as
But-
per this act, he is not
My lord.
entitled.
The Commissioner of School Education, my lord, my lord, consider the representation, my lord, in the light of the judgment passed by this authority.
Yes, Mr.
Yes,
Commissioner of School Education, my lord.
Commissioner will
Commissioner of School Education, my lord. Madras.
oh, no, this is madrasa, the director.
Director of
Director of madrasa.
Director of Madras. So Madras, my lord, he is present, my lord. Director. কত নম্বর ইয়ে করেছে পার্টি নেই
Secretary of Minority Affairs is the part.
Director is not a party, my lord. Let him consider, my lord, in the light of the judgment.
Let him added as a party.
Yes, yes. To add as a party respondent, my lord. Thereafter, your lordship party, sir. Director of Madras. না আর কেউ নেই, এই তো
না, ইয়ে আছে তো। Secretary Minority Affairs আছে তো।
পারবে ও পারবে
হ্যাঁ, হ্যাঁ।
তাহলে রেসপন্স নাম্বার 2
Respondent number 2, let the respondent 2 be considered because he is the
Yes. Two is the
To
Secretary Minority Affairs.
respondent number 2.
now who has rejected your prayer?
Lordship, they rejected DI. Let the DI revisit on
No,
the,
my lord.
Hmm?
To revisit, my lord, to revisit the my lord DI.
in the light of the
In the-
judgment of Procedural.
Respondent number 4. Respondent number 4.
Secretary is the higher authority. So
Yes, yes.
Minority Affairs has three wings. One is the Commission, another is the Board of Madrasa, another is the
DI.
Lordship, the Director.
A. Ask him to- I think in the light of the decision of Justice Bhattacharya, she is entitled to get it. Again, relegating the matter will delay the process. That is, will delay the process. Again, if rejection again,
Already, Lordship, the
again he
judgment
has
has
rejected the prayer.
Yes, my lord.
Again, revisiting on the basis of a judgment of this court will decide this.
Well, I submit before your lordship to revisit the my lord DI. To set aside the DI's order, my lord, thereafter to revisit in the light of the
In the
judgment.
similar circumstances where a prayer was made, Justice Bhattacharya considered that rejection, set aside, and then granted the fee.
Yes, yes. Ma'am.
Again, it will go back to the same authority. Again, a similar order will be passed. Again, he has to come to the court seeking for that. That will be futile.
Yes.
My lord, DI will send these documents to the concerned madrasa, that is the
Not required.
respondent
Now,
number 3, and they will
if
consider.
she is similarly circumstanced as of the Miturani Murmu, then she is entitled to get that. Again, revisiting on similar issue, rejection, again, this will be delayed.
Well,
What do you
Madrasa
say?
will consider, my lord, director of Madrasa minority. Secretary.
the Secretary.
Secretary.
अपना thing.
Hmm.
On the basis of proof that will be administrative tracking chemistry completed upon taking aside
Divide. AC South choice for
20th May 25.
2020.
that the joint as assistant teacher is
Distance. Distance. Twenty.
Along with necessary and regular input. Capacity. Care of the was defining of 22%.
Yes, 20th May 25.
He is not entitled to the same approval of expenditures act that is amendment 1960. Being acted by the action of the upon permission from the appropriate of granting in chemistry. But finding the provisions of the benefit that may be free in bracket based on the act of 1850. However, three,
Yes, 14th.
however, as per section 14, the starting law postgraduate scale of pay on the basis of a postgraduate. The provisions of law has been displayed by the Calcutta. Defining point or the subject that exceeding the circumstance petition was granted the contract is upon completion of graduate entitled to graduate seal of year. Precisely, the prayer of the petition was grant of post graduate seal of year has been turned down by the actual of the act of now to examine the relevant provisions of the success of the act of as given. Considering the aforesaid provision, the following being of this code is observed as Calcutta. Completed by postgraduate qualification right to the appointed decision. This code is of the application that is entitled to postgraduate scale of accordingly. The order dated 20th May 2025 of the district is the point number
Four, well.
of the Parganas is still alive. Report of our code is something directly record post-graduate of the seeking of publication of final results of part two examination within the period of table publication.
And this instruction is kept on record.
Yes.
What is that? Why? Good.
Dispose of. Dispose of.
For the I'm appearing for the petition. But in this matter, the last occasion, my learned friend, senior friend had submitted a notification of 1st of August 2024 saying that he has been recommended, my lord. My lord, only thereafter, my lord had passed an order for an inquiry report. My lord, I am seeking an indulgence from the honorable court, my lord. Before I place any documents on record, my lord, let my learned senior friend's client put this on affidavit before this court. It is very important, my lord, because this will
My
have.
claim was there that this has been handed over to me by the school authority, saying that you have already been recommended. There
Yes,
is
yes.
no need of continuing this matter. Get it off.
Let this contention be
Yes,
there
yes,
in
yes.
affidavit, and this document come on the record by way of an affidavit, my lord.
Yes, I need a
Yes, yes, my lord.
I need a full-fledged inquiry, my lord, against all those wrongdoer. Even if he is my client.
Yes,
Inquiry is
right,
required.
fine.
Yes.
Let him come with an affidavit. We will
Because my first
deal with this,
contention was
and
that
Lord will only give us liberty to file a counter to the supplementary affidavit only, not the main writ petition. Yes, yes, my lord. My lord, we want to put our issue on record so that the court can pass necessary orders. For that, my lord, we also will come with pleadings, formal pleadings. Yes, my lord. Obliged, my lord. Obliged. না না এটা accept করবেন না। Obliged, my lord.
উপরে করো সেপ্টেম্বরে তো অর্ডার পাস হয়েছে
এইটুকু ডিসেম্বর দেওয়ার কথা ছিল, এইটুকু ডিসেম্বর দিইনি, তারপর কন্টেম্প ফাইল করেছি, তারপর কন্টেম্প অর্ডারও হয়েছে।
ওটা কন্টেম্প হিসেবে এসেছিল
This happens came out before your lordship in the paragraph one of the order.
তিনটে অর্ডার পাস হয়েছে ও তাহলে তো আমরা
Lordship had 2024, lordship. Correct.
I am for the district prime minister. I am for the petition. This is a restoration application. The matter was dismissed on the 4th November 2024, my lord. And restoration filed, my lord, 17 December 2025.
My lord, this is not a restoration of the writ petition. This is a restoration of the application for correction.
Yes. For correction. Kindly see, my lord.
My lord, in the writ petition, there is an order directing the board to supply the result to the petitioner. At the time of passing that order, it was not pointed out this is a selection process of 2009 conducted by the DPSC South 24 Pargana. So instead of board, the council may be directed to give the result to the petitioner.
2009.
2009 selection process.
Well, kindly see page 60. This is the order. 16. This is the order. Only correction was successful with case 2014 instead of 2009, my lord.
No, respondent number 3 is a board. So there need two corrections. One is that is the you are successful in the TET, not in TET, but 2009. And instead of respondent number 3, council may be directed to give the result to the petitioner. Communicate the result to the petitioner. Recruitment process of 2000. My lord, success, we cannot declare him a successful. He may be successful in a written test. He may not be successful in the interview. But he has participated in the 2009 selection process. He participated. He wants to know the result of his candidature. My lord, the board court is directed to communicate the result to the petition. Plenty of error.
When we file a representation, my lord, kindly read petition. Read petition, we file a representation, my lord, 2009 Recruitment Board. But it is when the order was passed.
Or my lord, may I indicate one thing? My lord, kindly restore this restoration application and direct the council to come with a report. So that if he is successful, my lord, we can give a report that he is successful, and under that report he can once know his result. My lord, my lord, in the meantime, he filed Can 1 for recalling of this order.
Recalling of
23 order. And that has been dismissed. But he already there.
Therefore, we made a restoration application for the dismissal. Yes, therefore, due to defect, we made a file an application. That application appeared before the Honorable Gangwada. In the meantime, matter is appeared before the Honorable Vishwajit Basu. At the time of hearing, we are not appearing for this particular.
DT to dispose of.
You have made prayer for recalling of which order?
23 order. Kindly see the order.
Prayer to that.
Page 9, man. OBE Gangwar, the order passed on 80. Page 9 of which can, that can also allowed.
Can number,
Can
can
number
two,
two.
my lord.
Yes.
It is the order of this court. Of by the order. Subsequently, came up was we have received the requisition for people. Consequently, can 1 of 2023 until the order dated 4th November 2023 called, then you cannot come to the recalling of that order of Parliament is closed. Step by step, we have to come. Now come to the clear portion of your application being can of 2023. The exploration of order dated 14th.
Yes.
This clearly is also wrong. The can application number
That can man already allowed. That can already allow.
which can.
You can 1 of 2022, that also allowed. Yes,
Where is that?
কোথায়
allowed.
অ্যালাউ হয়নি দাদা ওটা
14/6/2020. Application allow, my lord. 14/6/2020.
একটু বের করো বি
14/6/2023. Yes, ma'am. That is not annex, my lord. Yes. On the basis of the, we find an application for correction. Correction was, Mala, that the correction was at the time of, he appeared before the origin Gangwar. There was subsequently matters that appear Vishwajit Basu. Yes.
Try to understand. Order passport disposal of requisition.
Yes.
Subsequently, when the can application appeared before this court, the requisition again dispute for it. But order is there. There is no such application for recall. You are seeking for restoration of that order.
Only I am seeking, my lord, only application recalling.
না ma'am.
Only recall.
Ma'am. I found page 7, ma'am.
Sir, can one of the
Well, it should be can 1 of 2023. That's not a fresh withdraw করে fresh file করো।
তার মানে রিপিটিশন সবাই রিপিটিশন
লিবার্টি নিয়ে একটা fresh all correction করো না, যে কোনো একটা করো, এটাতে হবে না। কি হয়েছে? আর ঘরে ডিসমিস মামলা ডিসমিস আবার ডিসমিস হয়েছে।
না ডিসমিস ওই সময় ডিসমিসটা হয়েছে রিপিটিশন
এটাতে ডিফেন্স আমরা আবার ডিফেন্স হয়ে গেছে, আবার কি হবে?
kindly liberty may given we made correction that here madam.
File fresh application.
And
But I am not. I have.
section 5 there.
My lord, let me take instruction because my lord, we also, my lord, work together. If we can help him, my lord. My lord, since none appear for the state, your lordship can engage with. আমার কেন? না, আমি শুধু. No, my lord, I'm with him. কেন?
Yes. Restoration along with application.
When the read petition was disposed of, the court became functus officio. Therefore, there is no question for recalling that order.
But the subsequent order
That was, yes. Justice Basu's order, then he has to file an application.
কি হয়েছে বলবেন তো?
From the DPW police appearing was attending the job of the state. That notice has to
piece of notice upon the learned advocate for the state.
My lord, I'm for the petition.
Yes.
My lord, in item number 5, my lord, I have Ms. Ghosh is appearing. One application is for the restoration of the application and the other one is for the delay.
How many days delay?
But 36 days delay. Delay of 36 days to file this restoration application. Has been dismissed by Honorable Justice on 4th November on 2024 and it has been filed, my lord, in January. The delay of 36 days.
Can 2 is the
Can 2 is the, my lord, delay application.
application, can another is can 1.
One is the restoration application, my lord. Can 2, para number 4, my lord, has stated that delay of 36 days.
Where is the reason given? The reason?
My lord, para 3.
But please,
And the restoration reason has been given, my lord, in para number 9.
it's para number.
In restoration, para number 9. But that day all the matter has been dismissed. Stated here,
Ah,
stated.
you are for the state.
My lord, Miss Ghosh is appearing for stay due to some personal difficulties. She is not present. I'm praying for a adjournment.
নামটা লিখে দিন। আপনার নাম দিন।
Affidavit of service. You have filed already.
Yes, ma'am. I filed the affidavit. This is affidavit service.
This is an application for
No, date.
Can 1 of 2025 with Can 2 of 2025. Very good. These are the applications for the restoration of the writ petition upon condonation of delay. Mrs. Jenia Rudro, this writ petition was dismissed for default on
4th of November, my lord, 2024.
4th of November 2025.
4th.
4th.
Yes, ma'am.
4th of November. 4th of November 2024. Miss Jenia Rudro, learned advocate appearing for the applicant, submits that the learned advocate could not appear when the matter was taken up by the Honorable Court, which resulted in dismissal of the writ petition. He seeks for restoration of the writ petition upon recalling the order of dismissal. Learned advocate for the state leaves the matter to the discretion of the court. Upon recalling the restoration of the writ petition upon recalling the order and condonation of delay. Upon upon going through the averments made in the application, it is found that the cause shown is sufficient to recall the order of dismissal upon condonation of delay. Accordingly, the order of dismissal dated 4th November 2024 is recalled. The writ petition being WPA 21530 of 2023 is restored to its original file and number. Can 1 of 2025 along with Can 2 of 2025 stands disposed of. Writ heading lists this matter. What is the writ petition about?
My lord, regarding the interest of the pension amount, my lord.
Oh. List this matter after 2 weeks under the heading pension matters.
Yes, my lord. This is a pension matter.
Pension, it's application. Pension matter after 2 weeks.
My lord. Yes, my lord.
Lord,
And I am for the petitioner, Lordship.
reply কই? আমাকে দাওনি? হ্যাঁ, কই? পেয়েছো?
Actually, last the direction to file affidavit in reply, affidavit in reply.
Where is the affidavit in opposition filed by the state respondents? Filed by state respond number 5 is taken on record. Affidavit in reply filed by the affidavit in reply to the affidavit in opposition of respond number 5, comma, filed by the petitioner is also taken on record. দুটো দিয়ে লিখে দিন copy served. Copies give us?
Yes, yes. of course.
Yes. What is this writ petition?
My lord, this is a matter regarding disbursal of 10-year service benefit. My lord, there was an allegation that the petitioner has misappropriated the fund of school and an FIR had been lost. But the police has filed its final report with a prayer of discharge. And finally, the court has discharged the petitioner. Till now, there is no allegation against the year. He is in regular in service, but the 10 years benefit is not disbursed. Now it will be 16 years, my lord. 2 years after it will be 18 years benefit.
Yes, Mr.
My lord, I have stated my stand, my lord, at paragraph 4 of the affidavit in opposition. So, my lord, Lord, here, my lord, I have elaborately stated, my lord, it is, my lord, the madrasa authorities has raised some dispute regarding his functioning at the time of teacher in charge. My lord, I read your, my lord, my lord, read certain portions, my lord, paragraph 6 at page 3. My lord, there was an allegation raised against the teacher in charge while she was functioning as a teacher in charge, and that was, my lord, considered 2 times hearing notice was given. My lord has got it.
Paragraph 6.
Page 3, paragraph C.
C.
My lord, hearing was taken, my lord, because 2 times intimation was given, he was not present. Hearing was made, my lord, in her absence. My lord, the hearing was stated in his absence as she has not intimated the reasons for her absence, and he was not made any further prayer for time. Mahmuda Nargis, present TIC, alleged that Sahida Yasmin, former TSC, the petitioner herein has not yet handed over the midday meal, vocational course, and cash-related papers, registered documents to the present TSC. She also kept herself a computer set and a printer of the madrasa. She has not even handed over the AC cash, which was received by her from the previous TIC, Fatima Khatun. Nargis further alleged that misappropriation of funds by Sahida Yasmin, Muhammad Julfar Arif, clerk, confirmed that Fatima Khatun handed over all papers, registered documents properly to Sahida Yasmin when she was engaged as TIC in place of Fatima Khatun. According to him, Sahida tried to misappropriate fund of the madrasa. He added that Sahida took the computer printer for his personal use. Shom Shukla Ghosh, the contractual, said that no paper has been handed over by Nargis as alleged. My lord, this is a dispute, my lord, and to that dispute, my lord, I draw your lordship's attention that there is a dispute regarding the handing over charges. My lord, I further, my lord, draw your lordship's attention to the provision of giving the benefit. My lord, paragraph 12. Paragraph 12, my lord, kindly sees. With regard, my lord, with regard to the statements number, paragraph number 8 of the writ petition, I say that the memorandum is clearly stated that will get one additional increment in the same level upon completion of every 10 years continuous satisfactory service. There are several allegations against the petitioner which has not been properly controverted by her. The petitioner has avoided in giving reply to the allegations as placed against her by the present TIC. Thus, the allegations against her cannot be hold to have 10 years continuous satisfactory service, so the petitioner is not entitled. My lord, the thing, my lord, we have given the emphasis on the, my lord, word satisfactory. My lord, satisfactory service entitles the petitioner to get the employment. My lord, I further, my lord, draw your lordship's attention to the my lord, page 10, annexure R1. Here, my lord, the district inspector of schools, after receiving the, my lord, complaint from the present TIC, after giving 2 times notice to the my lord Sahida Yasmin, the petitioner before your lordship, he has my lord gone into the factual aspect of the matter and whether he is entitled to or not. My lord, according to this, my lord, we, my lord, our contention is that according to this hearing, she has not rendered satisfactory service, which is my lord, the pivot of giving the 10 years benefit. So she is not entitled to that. That is the, my lord, main contention we have raised in this affidavit in opposition.
May I submit? My lord, that is the matter of 2018. Now come to page 15 of my writ petition, your lordship. School authority told me to make an application for 10 years benefit.
Maintain proper procedure.
That means my service was satisfactory. And the allegation, upon this allegation, they have lodged a complaint, my lord. In my affidavit in reply, your lordship kindly see, it has been annexed, my lord. They have lodged an FIR. Police has reported his file with a prayer of discharge. Subsequently, court has discharged the petitioner. So there is no allegation, your lordship. And no disciplinary, if there is unsatisfied any committed by me misappropriation, no disciplinary action has been taken. And finally, I have been discharged from the case.
Where is the order?
My lord, order I have during pendency of the, I have got the order, your lordship.
Madrasa authority going.
My lord, the FIR and the also is there.
Service commission দরকার কেউই নেই।
So it's not suspended.
No, my lord, that is, my lord, for the madrasa authorities, my lord, to state, because they are also made parties. My lord, kindly see that there is no presence of the administrator. What is the condition? Because we have, my lord, proceeded on the basis of the, my lord, allegations made against her. We have given our views on that. My lord, what prompted the madrasa authorities to, my lord, tell them to apply? It is for the madrasa authorities to tell before your lordship, because it is, my lord, as per, my lord, my noting, it is, my lord, probably under the heading hearing, my lord, because there also all parties are directed to file affidavits. My lord, they have not, my lord, appearing before your lordship. The madrasa authorities also have to say that
My lord,
these has all become.
time we have served for the second time, your lordship, the affidavit of service.
কি বলবে এটা? কি ছিল অ্যালিগেশন সেটাই তো আমি জানি না, কি এফআইআর ছিল।
ওই misappropriation of fund.
আরে মিস অ্যাপ্রোপ্রিয়েশন ছাড়াও তো এতগুলো অ্যালিগেশন আছে। Other than misappropriation, there are several other allegations. What is the now condition about the allegations? What did they say? We are not.
Who was the informant in the FIR? Who lost the
My
FIR?
lord, respond number 6, the
That is
teacher in charge.
teacher in charge. My lord, they are not appearing. This is the main difficulty, my lord. What has happened? What is the now condition, my lord? We cannot ascertain.
Not.
My lord, since there is no allegation exist, I maybe grant the 10 years benefit, your lord.
এটাকে নেক্সট উইকে প্লেস করে দিন। অ্যাফিডেভিটস এর নোট করেছেন তো? Learned advocate পদে the affidavit of service filed by the petitioner is taken on record. Learned advocate পদে petitioner is directed to intimate the next date of hearing to respondent number 6. What is the name of the madrasa? Teacher in charge.
Chaighari Girls High Madrasa. My lord, at page number 15.
Chaighari Girls High Madrasa HS.
Murshidabad.
And file affidavit of service on the returnable date. At a date for 2 weeks for it.
আমি বলিয়ে দিচ্ছি। রিসিভ করেছেন? হ্যাঁ, আমি বলিয়ে
Just
দিচ্ছি।
intimate the next date of hearing to the respond number 6. 11th March. Under the heading hearing. Hearing এর আগে রেখে। Motion এ রেখো না।
7 March.
Hearing রাখ।
I'm developing.
হ্যাঁ, এটা এখন ফেরত দিয়ে দিন।
My lord, shall I file with supplementary affidavit?
You can file. On the prayer of the learned advocate for the petitioner, leave is granted to file supplementary affidavit annexing the order passed by,
Passed by the
order dated,
order dated 25th September 2025.
by CJM or ACJM,
ACJM,
National Chief Judicial Magistrate, Murshidabad.
Berhampur, Murshidabad.
কপি একটা দিয়ে দেবেন আমাকে সাপ্লিমেন্টারি।
Item number 7, I'm saying for only not today, my lord. Then
10 মিনিট actually.
Not today.
Actually.
পরের week আসবে, not today করে পরের week আসবে। 10 to
Well, here, Lordship, today we will have to say Mr. Ahmed has already completed his argument on the last occasion. This is related to, Lordship, this recruitment in the Madrasa Service Commission in the post of the teachers. Today, Lordship, we have an application for addition of party, which was there. We are the candidates who have successfully participated. We are hopeful that we will be successful once the result will come. Lordship, if Lordship permits, then I can start. And if they have one application, I think.
May I present? Initially, there is 2 items, item number 10 and 11. Initially, the interim order first in item number 11, that is Masood Billah matter, my lord.
Okay.
That is the first matter in this score, my lord, where the pursuing candidate ought to allowed in the TET examination or not in the selection process. Here, my lord, case is slightly different, my lord. I will place the case, my lord, if my lord permits. Because of that, my lord, I will not take more than 10 to 15 minutes, my lord. I believe, my lord, that will be enough for me, my lord. My lord, may I place the subject matter, my lord? If my lord can-
My lord, I have a small submission. My lord, the Lordship remembers that this is a pursuing matter. For now, I have made my submissions. Well, I have received specific instructions since we are suffering a stay order, and whatever Lordship is going to decide, definitely we are bound to follow and we'll follow that. Only this since I have received instructions, that's the reason I'm apprising your Lordships. Any day there is a possibility of declaring the elections. Once that happens, then obviously this entire process, my lord, with nothing. So there is an, like every day the commission, they are facing, there are thousands of candidates for either of the sides. Now we are absolutely fine either way that Lordship decides, because the
We are
My lord,
also
today,
extremely
my lord,
awaiting for
it,
to
it,
get our
it will.
result.
I believe, my lord, today this matter.
So I think, Lordship, there are
Yes.
few
Well,
things.
I will not
Let-
take more
let-
than
let-
15 minutes, my lord.
Mr. Sham,
I believe, my lord, this matter will
this
be.
matter, let us do. Let me point out 2-3 things. Lordship, the case which is now on board, that is ABM Abdullah. Lordship, on the very beginning, I raised one serious issue related to maintainability of this. Lordship, kindly take one paragraph. Lordship, kindly come to paragraph 4 of the writ petition, and I strictly put the petitioners regarding the statements made. It's
My lord, I am appearing in respect of
Actually, জিনিস দেখে নিতে হতেই বলছি,
respondent, my lord, who has got the benefit of these pursuing candidates. My lord will hear me
Oh.
also. I need your assistance as to the chronology, how the applications is to be taken up.
Yes.
Now, Mr. Sami Mohammed has made his application. Mr. Sudipto Dasgupta has also made his
Yes,
application.
yes.
I have heard you.
Yes.
Now, with respect of the CAN applications, you have a CAN
No,
application.
no, no. I have a writ petition, my
Writ
lord,
petition.
as well as the candidate. My lord,
Okay.
item number 11, because this, my lord, this order
Hmm.
passed in item number 11 in Masud Billah matter, my lord.
Ah.
My lord will remember.
That is respect with the trade. Lordship, let me.
No. With greatest of
No,
respect, my lord, that is not the.
that
respect
has
of
a
the
bearing
trade.
in this matter,
My
my
lord,
lord.
my lord.
That too has
That's
a
have the bearing, but they are eligible to participate in the selection process. I will apprise this court.
Lordship,
Otherwise, my lord, the whole selection process will be set aside. I will, my lord, satisfy the court, my lord. Otherwise, this selection process must not.
You have filed CAN application in which item?
10, item number 10, can application 4 and 5.
4
In
and
item
5.
number 11, I am for the writ petitioner.
Item number 10, Lordship, my can 1.
So
May I start?
your submission with regard to 4 and 5 and the writ petition is same.
Yes.
Same.
Yes.
Same.
No,
Con-
writ petition is not same.
So
No,
is same application.
Same
Doc,
thing.
you
Same.
You note
Lordship,
please, no?
kindly come to Lordship, page paragraph number
All
4.
are the beneficiary of that.
Definitely I'll come to you. Let
Item
you come
number
to
11. Entry order. को देखिए entry order का था. हमारा iPad का था. 9.
My lord, I appear for NCT in all these matters. I seek indulgence to appear online, lordship. In all these 3 matters, lordship.
Initially, Honorable Justice Biswajit Basu passed the order in item number 11 on 9th June 2023.
Who is appearing for the petitioner in ABM Abdullah and others?
Mr. Shamim Mohammed was
You have filed an opposition to the CAN application? No.
Who can? In my can, my lord, in
No.
can 4 and 5, there is no such opposition.
So against which can they have filed the opposition?
I have no idea.
কি হয়ে যায় শুরু করো ফালতু সময় নষ্ট করিও না
Yes.
My lord, kindly take the main matter, my lord. This is very short point, my lord, involved in herein, my lord.
Only 2-3 points of laws are involved, nothing else, my lord. And even lordship, whether this will at all maintainable or not, that your lordship will have to test. Some fence sitter will come today, arise out of the slumber, and they will file the writ petition and obtain a stay. This cannot be permitted. After 2 years, they will wake up from slumber.
Can 4
and
it-
can 5.
can
My-
4 and 5 are same? Prayers are same.
Yes, my lord. The addition of party, my lord,
Addition.
we are the beneficiary of that, my lord, interim order, my lord. Being a pursuing candidate, we are allowed to participate in the selection process, my lord. But ADM Abdullah রিটটা দাও। ওদিকে আমি বলি শুরু করি। আব্দুল্লাহ রিটটা দাও। Yes. What a mess. My lord, I start from, I want to kindly take item number 11, writ petition, and item number 10 also, because, my lord, some of the essential, and I believe, my lord, my NCT, my lord, that NCT, my lord, bunch
It is
with
there.
you, my lord, NCT.
What is item number?
The spiral
11.
binding, my lord, kindly
11.
keep the spiral binding. It will helpful.
WPA 3562.
WPA 13463. That is Masud Billah, Sardar and others. 13463. Masud Billah, Sardar and others. And another is WPA 3562 2025 ABM Abdullah. Here I file CAN 4 and CAN 5.
4 and 5 টা আছে তো এখানে? দেখেছো? চেক করে।
No.
করে দেখো না রিট পিটিশন নাম্বারটা দেখুন। এটা পাল্টালে Yes.
My lord, this is a selection process start in pursuance of a rule. This rule called, which is annexed with my writ petition, that is Masud Billah Sardar, page number 50.
Page number?
50, 50. What is it? This rule may be called the West Bengal Madrasa Service Commission Recruitment Selection and Recommendation of Person for Appointment and Transfer to the Post of Teacher and Non-Teaching Staff Rules 2023. Well, this rule defines what is the qualification. Well, kindly turn page number 54. Qualification defined 2A 35, Roman 35, 36, pardon me, 36, 54, qualification. Got it, my lord? Qualification means qualification of teachers as mentioned in these rules and as notified by the NCT as far as applicable in case of non-government aided madrasa of West Bengal. So what is the definition of qualification? Definition of qualification is very specific. As per the NCT, the qualification ought to be gathered by the candidate, then only he become an eligible candidate to participate in a selection process. Now, my lord, kindly take, my lord, although it is annexed with this ADM Abdullah, but I will, my lord, request my lord to take my spiral, my favorite spiral, that my lord, minimum eligibility criteria narrated in NCT is a non-paginated, my lord. This is, but in ADM Abdullah, it is annexed, my lord. I saw ADM Abdullah, it is annexed. In ADM Abdullah, sorry, yes, ABM Abdullah,
It is annexed in page number 79.
Yes.
In ABM Abdullah, page number 79, thereafter. This is after Right to Education Act came into force. This is a minimum eligibility criteria. First time, the way of notification, NCT published it. Because in the NCT Act, by amending the NCT Act, Section 12, where Malol will remember, I placed in last occasion, NCT, earlier there was just an authority who just supervised the Teachers Training Institute. Thereafter, after coming the Right to Education Act, under Section 23 of the Right to Education Act, NCT became the academic authority. And NCT is the responsible authority, become the responsible authority throughout the country, what would be the minimum eligibility criteria. And on that score, it is written, in exercise of the power conferred by subsection 1, section 23 of the Right of Person of Free and Compulsory Education Act 2009, issued by Department of School Education Literacy such and such, Government of India, National Council of Teacher Education hereby lays down the following minimum qualification for a person to eligible for appointment as teacher in class 1 to 8. So NCT determine what would be the minimum eligibility criteria. So that is the qualification. Now, Malat, kindly see from class 1 to 5 and 6 to 8, what is the minimum eligibility criteria. I just take Malat class, this is upper primary, that's why Malat class 6 to 8, very next page, page number 80. BA, BSc, got it, Malat?
Yes.
BA, BSc and 2-year diploma in elementary education. There is a composition of two qualifications. One is that general academic qualification. Another one is that teachers training qualification. Got it, my lord? This is combination of two. Or that is disjunctive clause. BA, BSc again, at least 50% marks and 1 year bachelor in education, B.Ed. So one general degree, another one is professional degree. So general degree plus professional degree, that is minimum eligibility criteria. Now, Malat, kindly came just after this 1A, there is an adjunctive clause and passed in teacher eligibility test. That is TET. So become a teacher, 3 requisite qualification is essential. One is one general degree. Another one is one professional degree. Another one is TET. So 3 requisite qualification ought to be with a candidate. Then only he become a eligible candidate. Now, my lord, after passing this interim order, that pursuing candidate is allowed to participate in the selection process. One repetition came, this ABM Abdullah came. Now, my lord, what was his averment? I just, ABM Abdullah. What he wants, what is his prayer, and what is their averment. They are not eligible to participate. If my lord's hold, 2 things might happen. My lord's hold that this candidate who participate in a selection process as a pursuing candidate, they are not eligible in the selection process because they have not requisite qualification. Requisite qualification. I raised this question, whether ABM Abdullah have that requisite qualification on last cut-off date. Anywhere they stated, yes, on last cut-off date, I have TET qualification certificate, because according to the TET conduct guideline, 3, they ought to TET first, TET certificate will be.
As per you, 3 qualifications are necessary.
Yes.
One is graduation, another is a professional degree, and third is a TET.
Yes.
Now, a pursuing candidate, as per order of Honorable Supreme Court as well as the order of this court, can
Pursuing
participate in TET.
they are eligible to participate in TET.
We have to see whether the other 2 criteria are also fulfilled or not.
At the time of selection. Now, question is that what cut-off date will be determining factor. What would be the last cut-off date? If they says, suppose the last cut-off date, according to them, I don't know which one they determine as a cut-off date. 12 June 2023, if that is the last cut-off date, I rose that question. If according to them, on that day, this candidate have not requisite qualification, that is training qualification, I also raised that question, whether you have a TET pass certificate or not. Because ABM Abdullah was not TET passed on that particular date. He is an ineligible candidate. If he hold that on particular date, the Masud Billah, that person have not requisite qualification because their training was undergoing. That's why they are not eligible. On particular date, they also have not any TET certificate. Being an ineligible candidate, they raise the question. Although in pursuance of court order, Masud Billah participated in the selection process. Others can similarly situated candidate, being a pursuing candidate, they also participate in the selection process. But every recruitment process, every selection process, which hold, that is already governed by its rule. I will place the rule later on, because what is the exact position? Because if they says the Masud Billah and others pursuing candidate, they are not eligible, then they ought to accept that they are also not eligible. But my submission is that both are eligible. If Masud Billah is not eligible, then ABM Abdullah is also not eligible. Then whole selection process ought to set aside by this court. Because of that, on particular date, no candidate was eligible. If this court hold on a particular date is the last cut-off date, and on that last cut-off date, the qualification ought to be there. Because of that, by showing an advertisement, because this is a complete misinterpretation. I believe my learned friend showing this information guideline, which is annexed to my petition, page number 75. Page number 77 is the requisite paragraph. That is para 16. Qualification will be as on last date of application. I believe time and again they shows it.
Para, page number?
77, para 16. Item 11, that is.
Yes.
Because by showing this says, my lord, kindly I read it just all the single paragraph. 16. Qualification. Got it, my lord? Qualification defined in the rule. Rule says as per the NCT. If ABM Abdullah holds it, qualification as per their submission, qualification ought to be on the last date, that is 14 June, although 3 corrigendum notice, it was in the month of July in the year 2023. If they hold it on that particular date, others candidate who was the pursuing candidate, they are not eligible, then ABM Abdullah was also not eligible. Being ineligible candidate, they participate in the selection process because at that point of time, at that juncture, they not possess any TET qualification certificate, or they was not a TET qualified candidate. So being ineligible candidate, they participate in the selection process. The whole problem started because of not giving a particular notification, or the madrasa, they jumbled the TET with the selection process because they ought to publish it separately. That ought to be the model, but they published it. I will show a notification. Thereafter, I will because rule is very specific that because this is a first time TET hold by the Madrasa Service Commission. Because earlier occasion, they combined TET with written examination. This time, first time, they hold TET examination and main examination. So I could say, well, they ought to separate the TET as well as the written examination, but the rule itself permit them take the examination combinedly. I will place that rule later on. What is the rule? So my first submission is that, my lord, if this court hold the last cutoff date is 14 July 2023, then ABM Abdullah is also not an eligible candidate, or others who are the writ petitioner in item number 10. And not only this ABM Abdullah, not a single candidate is eligible to participate in this selection process. This is a legislation for giving equal opportunity to all citizens. Because in our country, there is no right of getting service. There is no right of getting public employment. But equal opportunity in public employment, that's the fundamental right. What is the rule position, Malad? I just, Malad, place the rule. No. Malad, I just place rule 7, manner of selection. Start from page 50. Relevant page, page number 55. What it matter?
Yes.
This is manner of selection. Rule 7. Selection to any post shall be made on the basis of result of state level selection test SLST, which may comprise any or some of all of the following as may be decided by the Commission. A. TET General and TET Arabic. So there are two TET. One is General TET, another is TET Arabic. Who am I? We are TET Arabic. For undergraduate category teacher for class 1 to 4 and TET General and TET Arabic. For general category teacher for class 5 to 8 of all MCQ OMR format. B. Preliminary test for all categories of non-teaching staff. C. Main examination MCQ for all categories of teaching staff of postgraduate, graduate all, undergraduate all, and headmaster, headmistress, superintendent, and all categories of non-teaching staff. D. Computer typing and computer proficiency test for clerk, interview for all categories of teaching and non-teaching staff. F. Verification of qualification as applicable for all category of teaching and non-teaching staff. 2. Commission may fix the minimum qualifying marks in preliminary test. The next one is the relevant one, the most important. Candidate who qualify in teacher eligibility test, got it, my lord, will be allowed to appear for main examination of corresponding SLST. So whosoever a TET qualified candidate is eligible to participate in corresponding SLST. This is 7 SLST. And also the main examination of subsequent SLST. So the rule is very specific. Whosoever qualified TET, he is eligible one to participate in corresponding SLST. That means that particular SLST. And the subsequent SLST directly main examination. That means on that particular SLST, whosoever passed it, he will participate in the selection process. Their interpretation is wrong, completely wrong. I'll show because of that, my lord, it is mentioned in the rule itself that what would be the academic qualification. It is mentioned itself. And subsequently is subject to age limit and fulfillment of other requisite criteria. So if a person on the date of verification or date of main examination is state qualified, age limit or other requisite qualification at the time of main examination is the eligible one. Because NCT says pursuing candidate is allowed in TET. Now this rule says whosoever TET passed allowed in corresponding SLST. NCT give us right to participate in TET. This rule gives us right to participate in selection process. If they hold it, if this court hold it, that no, contrary to the rule, the last cut-off date on the particular date ought to be the qualification, then not a single candidate would be the eligible one. Even they got the service, after 7 years or 10 years, their service might be done. Because of that, if that point hold, that yes, the minimum eligibility criteria ought to be on a particular date. Because they also not get the TET certificate or there was not TET qualified candidate.
Sir, I am talking to you. Who is this person? Why are you talking on mobile phone in courtroom? Who are you? You are a petitioner over here. What is your name?
Huh?
Your client?
No.
Petitioners.
Petitioners in item number 10.
What is, sir? You have to be aware of it. These things are not happen in court, na? Please don't do it. Ask him to go out of the court if he has any important call, receive that call and then come back. Yes.
What can I say, my lord? Although I don't want to mention it, because of that, although I'm in high fever, my headache is there. But some of the candidates, my lord, they WhatsApp me. If you're not present today in the court, because they are not my kind of client, we will go to your chamber. We will show agitation to your chamber. That makes this WhatsApp.
Now the fever has come down.
Yes.
Well, they will become the teacher.
Sometimes
it's very
fever has a variety of medicines. Variety of medicines.
So,
quote and unquote.
Yes.
So, my lord, I just. Yes. So, my lord,
55.
Yes.
Page 55.
55, my lord. So, 3. So, NCT gives us opportunity to participate in the TET, and thereafter, being TET qualified candidate, they will participate in the particular SLST. That is the rule. Rule is very specific about it. Thereafter 4, because from where it is started, the selection process, it is mentioned in the rule itself. 4, the commission may introduce negative marking for wrong choice of option. Candidate that ought not to be there, because that is also challenged in other interpretation, but because of that, according to NCT guideline, there is no such. There ought not to be any negative marking. In Arif Rahan matter, that is challenged. So 5, that rule is itself challenged. 5, candidate will be called for interview on the basis of marks obtained in main examination. Final merit list will be prepared on the basis of marks obtained in main examination, marks obtained in interview and computer typing skill and computer proficiency, as the case may be, as specified in Schedule 2 and 3. Marks of TET will not be taken into consideration for preparation of publication of final merit list. So TET is a minimum eligibility criteria. If they pass TET, then they will participate in the selection process, which start from main examination. So main examination, the selection process herein start from main examination, because state marks will not taken into consideration. Just state pass, because this is a first time state. For that reason, rule is very specific that whosoever TET passed, he participate in corresponding SLST. After TET pass, on that particular on main examination date, subsequently they made the notification on a particular date. Because that is the initiation of selection process.
19 June.
No, my lord. That is, my lord, 12 December 2024. In Can 5, it is annex page number 28. That is the date.
Page number?
28. Sorry. All right, I just showed page number 28, 29, and 23. I just read it. Important notice. It is hereby notified for all concerned that result of the 7 SLST 80 TET Arabic for class 1 to 4 and 6 to 8 and 7 SLST 80 main examination for class 9, 10 and 11, 12 will be published on the website of the commission and such website on such and such date. Verification of document of candidate qualifying in 7 SLST 80 TET. It is hereby notified for all concerned that verification of document of all the candidates who have qualified in 7 SLST 80 TET Arabic for class 1 to 4 and TET Arabic and Advanced Arabic for class 5 to 8 will be held from such and such to such and such date, except such and such from such and such to such and such time. I just skip the letter for verification of document can be downloaded by concerned candidate from website of commission such and such from such and such onwards. So, my lord, it is from this notification, it is clear on the date of verification. If they are TET qualified, if they have requisite qualification, they will participate in the selection process. Thereafter, my lord, interview and verification and document of candidate called for 7 SLST 80 interview. It is hereby notified for all concerned that verification of documents and interview of candidate call for 7 SLST 80 interview for classes 9, 10 and classes 11, 12 will be held from 6 January 2025 to 15 January 2025, except 12 January 2025 from 10:30 AM to 5:30 PM at Baitul Haj House, such and such. The call letter for interview and verification of document can be downloaded by the concerned candidate from the website of commission such and such. Main examination notification. Now, my lord, main examination notification annex in Can 4, page number 18. This is the most important notification, because on main examination date, if they have requisite qualification, then as per my humble understanding, then they are the eligible candidate. Why they are the eligible candidate? And Article 12 authority, that is Madrasa Service Commission, they, by following the rule, they gave opportunity, but initially they not gave opportunity to the pursuing candidate in pursuance of court order because of the NCT guideline, state conduct guideline, they are eligible one. And after participation, being eligible candidate, after verification, they participate in the main examination. But kindly see that they gave this notice on that day. If they are not eligible, then any candidate.
Page number?
18. Can 4.
80. 18.
Page number 18. 18.
Yes.
It is hereby notified for all concerned that main examination of 7 SLST 80, Arabic and Advanced Arabic for classes 5 to 8 and Arabic for class 1 to 4 will be held on 19 January 2025 Sunday. The admit card can be downloaded by the concerned candidate from the website of the commission. So that is the crucial day. On that day, if they are eligible one, then they are eligible to participate in the selection process. If this court hold that no, on the month of July 2023 would be the cut-off date, because here the whole question roving around the cut-off date, which would be the cut-off date. The cut-off date to gather the qualification ought to be the main examination date. Why? Because of that, in the rule itself, Rule 7, Sub-Rule 3 says, whosoever TET qualified, they will participate in corresponding SLST. That is most important word in this regarding this matter, my lord. In corresponding SLST and subsequent main examination. So rule itself gave the pathway to participated candidate to participate in the corresponding SLST. Here, if they, this item number 10, if they says the no, that would be on 14 July 2023, then they are also not eligible to participate, because they on that particular date, they also not possess the TET qualification. Because TET is also a minimum eligibility criteria to participate in a selection process. On particular date, if you are not TET qualified, if you are not training, if you are not properly training qualified, if you are not having not academic qualification, then you are not eligible to participate in the selection process. So ABM Abdullah and others who file this writ petition, if they says no, that would be the particular date, that is 14 July 2023, then if this court hold it, then they are also become ineligible. Not only they are also, every candidate become ineligible, because this is a first time TET. In that is, there is two type of TET, TET general and TET Arabic. We are TET Arabic candidate. Now, my lord, what would be the qualification which is narrated in the schedule? What would be the academic qualification or professional qualification? My lord, I believe, my lord, my juniors, although I don't know whether they properly instructed me or not, time and again, kindly turn page number 68. Time and again, my writ petition, my lord. Sorry. Masud Billah Sardar. No.
Page number?
Page number 68, and I will show page number 70. But this is schedule 1 corresponding to the rule 3. What would be the educational qualification, including professional qualification, academic eligibility, and experience? Time and again, they referred item number 12, but that ought to be item number 16. And what is mentioned in item, what is the difference between item number 12, entry number 12, and serial number, entry number, what it matter? In bottom portion, entry number 12, and in middle portion of page number 17, entry number 16. I just place, my lord, both the entry. Assistant teacher of junior high, high madrasa, senior madrasa, high secondary madrasa for the post meant for graduate vacancies for class 5 to 8. Essential minimum qualification as prescribed by NCT. Again, it is mentioned as amended from time to time on the date of advertisement. Time and again, they shows it. B, desirable knowledge of madrasa education system, Islamic studies and culture. Note 1, I just not placed it. Kindly turn entry number 16. We are Arabic, subject of Arabic. This is for general subject, not for Arabic subject. Now, kindly see what is the minimum eligibility criteria of Arabic subject. Assistant, even on main examination date, if a candidate is pursuing one in the subject of Arabic, they are also eligible. That is the rule.
In all the candidates over here are of Arabic.
Oh, no, Arabic, and they are passed, my lord. They are passed just not only after last card. If this court hold, that is 14 July 2023, after just few days before TET examination, all the candidates passed the training qualification. Because my lord, because of that, my lord, kindly see my representation which is annexed with my writ petition, page number 91. We are 21 to 2023 sessions candidate. The last line of my representation. All the candidates. Session is important. Got it, my lord? We are the student of B.Ed 2021 to 2023 session. Our session is going to end between the month of June and July this year. That means 2023. And the form fill-up of MSc will be within the month of May and June. But as per the MSc rules, we are not eligible to submit our application for not having our final mark sheet of B.Ed, even though we have right to be eligible for upper and primary TET as per the NCT rule is concerned. Therefore, we are asking for the inclusion of the B.Ed 2021 to 2023 session student. So this is our humble request to please give us the opportunity to participate in the competition. So they are 2021 to 2023 candidates. They passed in the month of July. Now, kindly see entry 16. Assistant teacher for the page number 70.
70.
70. What is the essential qualification? Essential. Kindly flagged it and marked it. That is the most important. Assistant teacher for the post of Arabic in language group in graduate category for class 5 to 8. Essential. BA in Arabic, BA in theology, Kamil, Mumtajul, such and such, I just keep it. 2, that is most important. Degree in Bachelor of Teaching, Bachelor of Education, postgraduate basic training from any recognized university or any training recognized by the state government as equivalent to Bachelor of Teaching, Bachelor of Education, postgraduate basic training from teachers training duly recognized by the National Council for Teacher Education within bracket NCT in the relevant academic session. Well, kindly, what is the difference between the entry number 12 and entry number 16? Entry number 12 says on the date of advertisement for general subject, even on the date of main examination, if a Arabic student who want to be a teacher of that particular category, even a pursuing candidate is also allowed. Because of that, my lord, in the rule says so. Why? Because the session is different. Arabic, because there are Kamil, theology, Mumtajul, their session is something different to general subject. For that reason, the rule itself gave this opportunity. Participate in the selection process. For that reason, in entry number 12, this is on that particular date regarding educational qualification. But regarding the Arabic, this is a particular session, academic session, 21 to 23 session, they are eligible. Even if the main examination hold in the year 2024, then, my lord, whosoever is a pursuing one on that particular date, they are also eligible. As per this rule. Judgment kichu lagbe na. Eto সুন্দর rule obviously. I just not take more than 50.
Start with 15 minutes, but it goes on.
But what if
short date though? Short is coming week.
Further 15 to 20.
coming week. We'll come back to you. Let him complete. We make it. অন্য ম্যাটার আছে না মানডেতে রেখে দাও মানডেতে পেনশনের ম্যাটার সেকেন্ড হাফে নিয়ে নেবো 23rd.
23rd. There is a likelihood that on that day I may not be here on my personal ground, nothing to do with
24th.
Yes. Yes.
24th. দেখো 24th is second half.
24th.
Start at ওই 3টে থেকে শুরু করবো 20 কত 24th.
Yes.
3 p.m.
Yes.
24 থেকে আবার আমার কিছু
Sir,
And let him
complete your argument on that day because Mr. Chatterjee is waiting.
I will not go. I will complete. I will not take more than.
Also make a short summary. I'm the added party. I'm also in the same situation.
I have a different set of arguments. He has concluded, I think.
No, not yet.
Oh.
But after my
24th 3 p.m.
well, after my learned friends completes, I made my submission. Just 1 or 2 lines clarifications I want to make because I made a submissions. Just thereafter, I received certain instructions from the commission just to clarify.
আপনি কি কোনো এভিডেভিট বা কিছু ইউজ করেছেন
করেছি
আমাদের দিয়ে দেন
বিম আব্দুল্লাহ তো করা হয়েছে
And in Mr. Samim,
yes,
in your petition, is there any candidate of upper primary? Only primary is there.
No. This is upper primary.
It is upper primary.
It is upper
Primary, no primary.
Yes.
Upper primary.
Upper primary.
This is 5 to 8. All are 5 to 8 in Arabic.
Asum. Or
Because
Mr.
they
Firdaus
get
Samim, learned
opportunity.
advocate for the petitioner in Can 4 of Can 5 of 2025 in WPA 3562 of 2025 as well as petitioner in WPA 13463 of 2023. Due to paucity of time, hearing could not be concluded. List this matter on 24th at 3 p.m. 24th? 3 p.m. Thank you, sir.
My lord, I appear for NCT in all these matters.
One thing because of that, my lord, although my juniors mentioned throughout this week, my lord, it is regarding my lord special educator.
One Friday, I will take it up.
My lord, it will be kind enough. You take it tomorrow, my lord, because my lord.
How many matters are there?
2 matters only.
আর ওনারটা কতগুলো আছে অনিন্দ বাবু
একটা মানে
ঠিক আছে we'll see we'll collect the list and
otherwise my lord, if that is on the last day, some reason if not,
see.
that is the last
কালকে list
judicial
করবো।
order.
My lord, my appearance may be recorded, lordship.
Yes.
Grateful, lord.
Grateful.
Please, my lord. My lord, there was a misunderstanding about this matter.
Sure.
Number 46.
I'm for the petitioner, my lord. My lord, 46. My lord, may I be permitted to mention an original side matter?
46, who is for the petition?
I'm for the petitioner, my lord.
I appear for the state.
My lord, the matter is this, my lord. A notice was issued by Maru Masina Madhya Shiksha Kendra for a post of Champrosharika. My lord, the petitioner applied for the same having eligibility, and my lord, he was selected.
Who is for the state?
He is
They?
okay.
There are private.
Copy have been served. Copy served.
Yes, my lord. Yes, my lord.
Copy
Yes,
has
my
been
lord.
served.
Yes, my lord.
There is a private respondent, I understand.
My lord, that private respondent has retired from service, my lord.
Private respondent has been served also.
My lord, he was served earlier. He was served earlier, my lord. On the last occasion, your lordship picked the
Private respondent number. What is the number of the respondent?
private respondent number 10.
10. 10 was represented.
Yes, my lord. My lord, the
Very short question is in. Very short.
my lord, the petitioner was appointed as Champrosharika in the said school. My lord, after rendering, my lord, his subsequently her service was approved by the Panchayat Samiti. After rendering 5 years unblemished service, she was asked to appear before a committee, my lord, by a notice in 2012. That is, my lord, Annexure P4. Lordship may kindly see the notice. Annexure P4, page 25. Page 25, my lord. This is to inform you. Lordship has got this. Page 25. Annexure P4.
Private respondents have filed any affidavits?
Yes, my lord.
Uh,
Yes, my lord. Opposition and reply has also been filed.
no, no, private respondents have filed their opposition.
Yes, my lord. Respondent number 10 has filed the opposition.
Okay. It is hearing a date. Din Madam, you ensure service upon private respondent because this was dismissed for default, I suppose. One Mr. A. Haldar appeared for private respondent number 10 in the year 2020. Mr. Rudronil, they also appeared for private respondent number 10.
Yes.
Rudronil Dey. Yes, my lord. When the
Give a notice to the learned advocate as well as to private respondent number 10. Learned advocate for the none appears on behalf of private respondent number 10. Learned advocate for the petitioner is directed to serve notice upon private respondent number 10 as well as to his learned advocate and file affidavit of service on the returnable date. Release this matter after 2 weeks under the heading hearing. This of the 10th March. Under the heading hearing. Hearing to 2 p.m. Ragu.
To respond number 10 as well as this one.
Learned advocate.
respondent number 10 has retired, my lord. He has retired.
Maybe he has the address over there.
My,
So if the learned advocate fails to appear, then give a notice to the respondent number 10 as well, so that the appearance may be ensured at first.
my.
The 40. So 47? Oh, acha.
My lord, I am for the petitioner in
48, yes.
My lord, I
kindly,
appear.
my lord, give 1 day accommodation. My lord, my senior, my lord, due to health condition, my lord, he go back to my lord chamber, my lord. Any day, my lord, can fix this matter, my lord.
My lord, I appear for the Madrasa Service Commission. I have no problem if accommodation sought. It's a matter of 21. Still a motion.
No, my lord, it is hearing, my lord.
It's a hearing.
Opposition and reply is complete. Huh?
I have sent her.
Opposition reply complete.
Okay. Then I have to. Then I will check it again. It's a good that matter is be done tomorrow.
Yes.
Opposition reply already complete, my lord.
2 and 3 as filed on January 2023. On the prayer of learned advocate for the petitioner.
Advertisement dated.
Date bolo to hearing hai. Ye bolo date. Answer pore din.
I thought.
Answer pore din. Can order Rami Bindot aa jayega.
Well, this I don't think it has urgency because it's a six SLST. Even after that, there has been a 7th SLST. Every recruitment process is over. Now that's on merit. I don't think there is no urgency.
Every matter is some urgency, my lord.
That's from lawyer's point of view.
No, it's petitioner's point.
19th March.
19 March, my lord. Same heading, same time, my
Same
lord.
heading. In the second half, it will be taken up.
Same time. Gratefully.
My lord, I appear for NCT in this matter.
NCT data record appearance.
Grateful, lordship.
Negative, no?
Yes.
Well, this matter, Lordship has almost completed the hearing. That negative marking, I have also completed. Now, my learned friend would supposed to reply. That's only left out.
এটা কি মানে একদম টানা with এই অবধি
Like issue.
Yes.
It's been elaborately explained to your lordship by my learned senior friend for the madrasa. And we also, with our limited capacity, my lord, wanted to canvass the issues before your lordship. Now, my learned friend has, my lord, had relied on the proposition of law that if the advertisement goes contrary to rules, the rules shall prevail. Therefore, my learned friend, what he wanted to drive at, that recruitment rules is guided by NCTE. Since the NCTE rule, my lord, had prescribed a procedure not to award negative marking, and if the advertisement contains that there should be negative marking, that advertisement has no consequence, rule will prevail. And since the assessment of the marks have been made on the basis of the guideline given by the NCTE, therefore that assessment should prevail. They have followed NCTE guideline. But that I could understand, my learned friend understood. That is the issue. Now, my learned friend has relied on very strongly on 2018 volume 3 SCC, particularly paragraph 27 thereof. But I am giving handing over. Is it available to your lordship?
One copy must be there with your lordship.
Paragraph 27 in support of the said proposition.
Judgments গুলো যাতে আছে হ্যাঁ 2018, volume 3.
Yes, 2018 3 SCC, page 55.
Ashish Kumar.
So,
Has your lordship got it?
wait.
I have a ready copy for your lordship. I
No,
can
it
give.
must be marked by your lordship, so usually marking copy is always helpful.
No, ওখানে হবে না। তুমি সব এক জায়গায় করে দিন তো। দাঁড়াও, দাঁড়াও। 23 তুমি যদি দেখো এখন একটু প্রোভাইড করতে পারবে। If you have a copy, kindly provide that. We'll search it out.
Fresh copy.
Oh, yes. No, it is 19 at the edge. 19. দাও, দাও। Yes.
Well, my learned friend relied on paragraph 27 of the said judgment at page 64. I place it for your lordship. Any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. Thus, looking to the qualification prescribed in the statutory rules, appellant fulfilled the qualification and after being selected for the post, denying appointment to him is arbitrary and illegal. It is well settled that when there is a variance in the advertisement and in the statutory rule, it is the statutory rule which takes precedence. That proposition, my lord, I duly accepted, my lord. This is the law laid down by the Supreme Court. Now let me, my lord, take your lordship. This is the proposition in support of that, my lord. He has given some other judgments also. I brought it, but repetition, my lord, this is a proposition accepted by us. Yes, that is so. Now, so far as the rule regulating the recruitment of 7th state level selection test is concerned, lordship will kindly take the statutory rule relating to such recruitment.
Which repetition? 688 I take.
I am taking your lordship to that. Ruleta দিয়ে দাও না।
Which writ petition? 688.
It is annexed to, no, 688, it is not annexed.
Now, বলুন 31.
কত পাতায় annexed?
3120. 3120 এটা দাও।
2414 item নাম্বারটা কত? না, পেজ আমি জানি।
এটা দেখো তো।
আইটেম নাম্বারটা।
Page 22.
এটা তো।
আইটেম নাম্বার,
ঠিক আছে।
আইটেম নাম্বার।
Item number, sir, 51.
মানে in item 51, page 27.
Yes.
Well, this is the statutory rule. This rule is called, West Bengal Madrasa Service Commission Recruitment, Selection and Recommendation of Persons for Appointment and Transfer to the Post of Teaching and Teachers and Non-Teaching Staff Rules 2023. And this rule, my lord, in exercise of the power conferred by Section 18, read with Section 8 and 9, 8, 9 and 24 of the West Bengal Madrasa Service Commission Act. Madrasa Service Commission Act, and in supersession of the West Bengal Madrasa Service Commission Recruitment of Selection of Appointment for the Transfer Rules 2010, issued by memo number so and so, published in Calcutta Gazette. This is a statutory rule. This rule is governing the said selection. Now, in the said rule, if your lordship kindly come, rule sir.
7.4.
Kindly come to manner of selection. Yes. Rule 7 at sub rule 4 thereof. Rule 7 sub rule 4. That rule contains the condition the commission may introduce negative marking for wrong choice of option.
Yes.
Statutory rule as referred to in the judgment of 2018 volume 3 just now. That also speak of statutory rule, and this is the statutory rule which is governing the recruitment process in question. I could have understand, my lord, that this condition of negative marking as has been introduced, my lord, in the regulation and the other guidelines given for recruitment, information guidelines, 7th SLST, was dehodes the rules. I could have understood that. But this is not dehodes the rules. This guideline has been given in conformity with the power given to the commission to introduce negative marking. This West Bengal Madras Service Commission 7th SLST information guideline also, my lords, speak of condition number 11. Page 23 of the WP number 6120. আমি এটা এই গাইডলাইনটা বলছি information guideline. Has your lordship got it? Lordship will kindly, my lord, turn to 3rd page of the said guideline, clause number 11. There will be negative marking for wrong choice of option. 1 mark will be deducted for every 2 wrong answers. This is done by the commission, my lord, in the 7th state level selection test information guideline. A candidate, my lord, who is offered with this opportunity to apply, my lord, had relied on the guideline, relied on the regulation, and relied accordingly, he acted upon. Now, in the question mark, 7th SLST TET 2023, so far as the answer scripts are concerned, question answers, that is the OMR sheet, I should say. Is it the OMR sheet? OMR sheet. Lordship, has your lordship got it? That OMR sheet?
I have seen that there is a guide in instruction given that there will be negative marking.
Yes,
that you have
instructions
shown
11, clause 11. So, clause 10. There will be negative marking for wrong choice of answer. A desperate argument has been made from the end of the Madras Service Commission that a candidate who is getting an offer of employment on the basis of a notification published by the authority, such candidate is to test by purchasing the book from the market whether this particular notification is in conformity with the rules or not. Because rule will prevail. If you say that there will be negative marking, I should disbelieve you. No, you cannot impose negative marking. Therefore, I shall be giving answer to all questions at random, whether I feel it to be right or not. That offer you have given to me, that I shall be giving you negative, I should disbelieve it. What is what a situation of a candidate, my lord, who is before the Madras Service Commission. He will not accept the guideline given. He will not accept the regulation framed, which is like accept the rules framed by them. That this is the rule. And accordingly, my lord, this has been imposed. Now let me come to the argument of NCTE. Kindly, my lord, consider the NCTE guideline. Is it with your lordship? And I am handing up to your lordship. আবার লর্ডশিপ কোথায় খুঁজতে যাবেন?
Yes.
Well, NCT guideline for conducting teachers eligibility test TET. Now, if your lordship kindly skips to up to 3rd page of the said guideline, but there is a pattern of allotment of marks for paper 2 class 5 to 8, where we belong to, that is upper primary. 150 duration of 1.5 hours. Has you lordship got it? My lord, kindly see child development 30 marks, language 30, language 2 30, for mathematics and science, for the science students only, because for others we are coming to social study teachers, social study 60. Well, in the question answer I have given to your lordship, 7th SLST, or the guideline given, kindly come to the information just I have given to your lordship, information guideline. Information guideline. Just now I handed up to your lordship. Page 23. Huh? 3120. My lord, kindly, my lord, take up the B, condition B. That is 1 to 4. And condition 2, 5 to 8. 2nd page top. Has your lordship got it? It is, my lord, just the replica of the NCT guideline to some extent. Difference I am showing you, lordship. Child development 30 marks. Has your lordship got it? Language 1 30 marks. Language 2 30 marks. How for social study, how Arabic and advanced Arabic coming? That is not according to the NCT guideline. If we are strictly following NCT guideline, I should have mentioned here that social studies teachers. Social studies 60 marks. We are all social studies candidates.
Yes.
Therefore, it cannot be even, my lord, said that that NCT guideline was followed strictly according to the terms and conditions thereof.
Yes.
Now, my lord, there are three class of candidates before your lordship today. All appearing candidates. One class, my lord, who appeared before the examination, before the examining authority. My lord, they are very alert that there will be negative marking. Therefore, they will not answer any question or try to make answer to any question, my lord, which according to them, they are not sure that this is the right answer. My lord, lordship knows, my lord, this is how, my lord, if a wrong answer is given, 2 marks, 1.505 marks will be deducted, 2 marks, 1 complete number will go away. So I shall be, my lord, very scared of, my lord, answering. Even the doubtful answers, my lord, I did not attempt. Second class, my lord, the persons, my lord, who are unprepared, semi-prepared or lesser prepared than us. They can take a chance. Let me try at random. Let us see. Ultimately, in the end of the day, I will not succeed. Let me go for the entire 100 marks examination. They made a random answer, 150 marks. And third candidate, those who are the meritorious class, where they are sure that this answer is right, they have made their answer. So, at the end of the day, my lord, after the examination is over, one order had come, not the notification, not an order passed in the name of the governor. Result was published. Successful, unsuccessful, all have been determined. Thereafter, you say, there will be no negative marking. So, where should I stand as candidate? Today, if you treat the candidates in this fashion, so therefore, either your entire procedure leading to holding of the examination was divorce the notification made by you, or divorce your own rules. Secondly, even if, my lord, you strictly try to follow NCT, there also, my lord, you are not following the NCT. Therefore, your own procedure, my lord, by social study, my lord, for your including Arabic.
But this could have been indicated at the time you filled up the form or the notification been given.
Yes. When I filled up the form, that
person who participates and there are subjects, suppose physics, chemistry, mathematics, and English.
I bow down to
within it. You don't challenge at that point of time when the notification was given. When there is a either you have not qualified or not, the rank has not been better. Now you say that the subject why it has been included.
This issue is raised by them. They are saying NCT. I accepted that.
No, as far as the subject is concerned, negative marking, I can understand that that was not there.
Subject also, I accepted that. I did not raise objection to that. Now they are saying that NCT I have followed. NCT speak of a different story. Their story is not in conformity with the NCT guideline. I have accepted as a candidate, receiving end. I am in the receiving end, I have accepted whatever you have given. And I have acted on the basis of the same. And now if you say, now I have been, there are a number of candidates who are disqualified or unsuccessful candidates belonging to my camp. They are, even not answered even 38 to 39 or 40% questions where they are doubtful. And ultimately, it will be seen if they produce it that even 1 marks, 2 marks, 3 marks deficit for that they did not qualify. 89 got, 90 is the qualification. 36 questions, the boy was telling me. 36 question I could not touch. I did not touch because I was doubtful. They are the victim of the entire situation. Now you have,
Yes.
Now you have held the exam. Unsuccessful candidates were not allowed to participate in the selection test. we are, because of the change stand taken with the negative marking. We are seeking some protection from the lordship. If it is assessed in the fashion that negative marking should be imposed, the entire list of successful candidates will be much reduced. List of successful candidates will be much reduced because a wide range of candidates have been allowed to enter into the second step, which we are not allowed. If it is reduced, there would have been a chance for us to be selected because of the last cut-off marks would have come down in comparison to the total number of candidates, to be taken into consideration. Say 500 seats are there, only 25 or 30 or 120 candidates are there. It is a case, you can carry it forward. But you could have considered our case also, that these are the marginal candidates who had accepted our regulations. The victim we are because we have accepted their regulations. And rules, the argument that has been floated, the rules have been contrary to rules. That argument has no legs to stand because the rules were followed.
Okay.
But that is exactly what I submit.
That's all.
Thank you. That's right. But I'm adopting my learning fingerprint argument. Reply. The first, at the time of making my submission, the writ petition, that I made a specific submission that Madrasa Commission, Service Commission is not guided by the NCT. That's my specific submission. Now, as per rules, the Madrasa Service Commission decided that they will follow the NCT rules while conducting TET. But my submission is to that effect is that yes, they have in their rules, they said we will follow the NCT guidelines. Not only that, in the rules, they himself says that we can extend our power beyond the NCT. But if you also can see the rules, page 20. But first, kindly come to the definition. Rule 2, sub-rule 27. Page 29.
Yes.
27, NCT means the National Council for Teacher Education. Next, 28. Teacher eligibility test means teacher eligibility test for primary and upper primary level covered under these rules conducted by the Commission as per NCT guidelines. Now, kindly turn over, kindly come to page 31. The manner of selection. Rule 7. Got it? May I read for you, Lordship? Rule 7, sub-rule 1. Selection to any post shall be made on the basis of the result of state level selection test, which may comprise any or some or all of the following, as may be decided by the Commission. Number Commission has said the test may be comprised of any of them, some or all of the following. So rule 1, clause A, TET general, TET Arabic for undergraduate category teachers for class 1 to 5, TET general, TET Arabic for graduate category teacher for classes 5 to 8. So in their own rules, they says they can take a TET for general and TET Arabic. But as per NCT rules, my latest reference shows to your Lordship, which is annexed in their opposition, there is no.
Again, a new fact has been argued now.
No, why I'm saying, Mal. There is no procedure for.
You proceeded with your argument that there is no scope for negative marking NCT, and furthermore, NCT guidelines has no application so far as the Service Commission is concerned.
Yes.
Now you are harping on a aspect which has not been argued by Mr. Dhar. What will be the subjects of it?
No, my lord,
whether the subject which has been given
telling
as
the
per the
subject.
guidelines of NCT or
I'm
not.
not
No.
submitting on the subject. What I'm trying to submit to your lordship is that the commission has the power. They acted at their own power. That's why they changed the subject from social science to RP. This is their power. They acted on their power. My case is that they says, look, there is no guidelines for negative marking in NCT rules, so we have wrongly imposed the wrong negative marking. That's why we withdraw. But my submission for today's lordship is that no, my lord, they have acted on their own power because they have decided to act as per the NCT with the rider to act their own power, to add their own power. That's why they say we will take TET on RB. There is no provision for subject RB in the TET. But yes, this is my submission. My regarding subject, regarding the others, I'm not submitting. Firstly, they are not bound by the NCT. Even if in the rules they says that we are guided by the NCT, but the rules itself, they have the power to proceed further, to act further with the NCT guidelines. That's why in the TET they added RB subject, which is not in that NCT guideline. Firstly, and secondly, in their guidelines himself, they say the commission may introduce negative marking for wrong choice of option.
Yes.
This is in their power, which has been given to them under the rules, statutory rules. So, I'm agree with the judgment showed my learned senior friend that if the advertisement is contrary to the rules prevail. But here, rules prevailed at the time of advertisement itself. The commission acted on their own rules.
So you say that the judgments which has been referred by Mr. Dhar supports your case. If the rules has to be followed, then negative marking is a correct proposition.
A correct proposition. Is a correct proposition. Well, that's all. Well, another submission I made in the while I am making submission of writ petition. Initial writ petition was filed challenging the advertisement, whereby the negative marking was introduced. No matter commission appeared, they sought an prayer before the honorable court for opposition and reply. But in the first instant also, they cannot say after publication of result, look, we do not have the knowledge, we made a mistake. But the first instance also, when the writ petition was filed before the honorable court, at the time of advertisement, they have the specific knowledge that they have introduced the NCT. I handed over to you also the last. I just handed over. Yes, I handed over to you.
Order date
WPA 23679 of 2020. This one?
Yes. Can you see the prayer? The state writ petition NCT appeared. I handed over the server. The state writ petition appeared and sought direction, and the court has passed an order of opposition and reply. So, on the first instance, they have knowledge that there is a writ petition whereby the challenge has been thrown to the NCT to the negative marking.
Only one question: the writ petition that my learned friend is referring to, is it in today's list?
No. It is filed also.
So if it is not there,
no, I'm just making a submission.
No, that's fine. But probably, if there is a X writ petition, X can take that point, not Y in other writ petition, because most.
I'm just giving an example to your lordship that they have the knowledge on the first instant.
Now here the they means others.
The knowledge. The board has the knowledge. The board appeared in the writ petition. The board contested the writ petition. There's a direction for opposition and reply, and writ petition is still pending. Whereby the allegation was that the board has not acted at. But if you also can see the prayer in the original writ petition, page 16.
Is it before ad or after ad?
Just after ad.
So once after ad, so it's already done. I said that
The advertisement has been challenged by this writ petition.
That's what I'm saying.
Kindly see page paragraph prior to holding the examination. Page 16, my lord. prior to holding the examination. A declaration declaring that in teacher eligibility test, negative marking is not permissible as the commission bound to follow NCT
Exactly.
guideline for conducting TET dated 11th February 2011.
Right, we followed that.
Well,
We
they have
followed that.
corrected. Why I'm submitting this? Because they know that they have acted on their own power. That's why initially they have not corrected. They contested the writ petition. But after publication of result, they came up with this with the alleged notification for withdrawal of negative mark. But this is not a bona fide mistake. I'll say this is an aid to the corruption. Why, my lord? Why I'm saying so? Because initially, a examination conducted amongst 10,000 people, wrong mark with the condition of negative marking. My lord, what my learned senior friend says, suppose 200 people did not give an answer in spite of knowing that there may be a doubtful answers they did not give. So 200 people deleted from the list. Now, kindly consider if the result published with the negative marking, there may be a past candidate of 200. 200 candidates may be passed. So the selection will be within the 200 candidates. Now, if negative marking goes, the selection will be the past candidate will be the 2000. So, my lord, why I'm saying so? A candidate who given answer randomly without having the knowledge of particular subject, now by way of amending the notification by withdrawing the negative marking, but they have allowed a less qualified candidate to be participate in the selection process with the candidate who, in spite of knowing that this is a negative marking process, in spite of that, pass the selection process. But this will give a aid to the corruption. But that is all my submission.
A lot. You have also something to say?
Okay, I'm 52 minutes. And your lordship, kindly visualize the situation, my lord. Page 37 minute. This was issued at the examination hall.
Is 37 of which writ petition?
611 minute.
Abu
Bakar Khan.
But prior to that advertisement,
yes.
Prior to that advertisement was issued, information guideline was issued, but this was issued at the time of examination hall minute. I have been directed not to do something which goes against me, minute. I have been directed not to give answer of any wrong question and the consequences of which also mentioned here, minute, at serial number 10, minute. So I have been restrained myself from giving any answer which I am not sure about the correctness of the answer, minute. So after the examination was over and they have changed the rule, minute. If they change the rule prior to holding the examination, I have no case, but examination was held on the assumption that if I give wrong answer, I have to get negative marking. So I have compelled by the commission not to give any answer which I am not 100% sure.
That's all.
The hearing may be concluded. Now, should we give one-page note necessary?
Intend to you can give a. You have.
I haven't prepared that. I was thinking whether just nothing on full sentence, just the bullet points in one page.
I can find tomorrow.
Just one page. I just thought about it.
You can make it short. Just
I said that.
Point is very
I said it should be one page.
One page.
Don't make it two.
Asun. Mr. Kamalesh Bhattacharya, learned
Lordship,
advocate.
conclude the hearing
Yes,
so that it is
a date is being fixed for filing the written
right.
notes. Kamalesh Bhattacharya, learned advocate in WPS 688 of 2025. Mr. Chittapriya Ghosh, উপরে cost title পেয়ে যাবেন. And Mr. Shahar Shah in WPS such and such, who concludes their reply. The hearing is concluded. Please this matter next week এ যে কোনো একটা date বলো, just it notify করো.
It will be on 2 minutes because I'll just file my. Next Wednesday.
Any day of
Monday
your
I'm
choice,
coming.
you have to take that. Mr. Pratik Dhar, learned senior advocate, seeks to file a short written notes.
But it will not be like a note, just the point, informal, so that
File
connecting the memories, nothing else.
short note with relevant points.
Yes.
Parties list this matter on 25th. Under the heading to be mentioned, parties are at liberty to put in their written points.
Lordship, record that hearing is concluded. No, why I'm saying it? No, because now the pressure from our part that goes. Nothing on our part has to be done, excepting that one
Now the
one page.
pressure shifts to which side?
Now pressure completely shifts to that side. That I every time I do understand it. It is
Make it very short. Make it very short. I have.
I said, but why I said so, because it has continued for a prolonged time. So I was finding sometimes difficulty to connect the basic, only for that reason.
Yes, thank you. Thank you, sir. আমরা এটা 49 থেকে শুনলাম। আচ্ছা 49 to 52 আচ্ছা কেন পুরো কিসের কেনটা তো কেউ আর্গুমেন্ট করলো না। আচ্ছা ঠিক আছে রাখুন, আসছে তো ডুই মেনশন সেদিন দেখ।
Yes, Lord, I'm appearing for the petitioners, Lord. Now, on the last occasion, Lord, my Lord was pleased to direct them to file the opposition. They took time, and my Lord, to file the affidavit opposition. And there was a direction for giving advance copy. So till date, my Lord, no opposition was heard upon us.
Why,
And,
sir?
Lord, today has been fixed for hearing.
Sir.
So, my Lord, now they are giving this, my Lord, the opposition, my Lord, the date of serving the copy, advance copy is all long back, my Lord, it has expired. However, my Lord, if they, my Lord, file this, my Lord, Lord, then they chance to be given, my Lord, to reply to that, my Lord. Otherwise,
This has
Lord,
been filed within time.
because I will
Yes,
have
my Lord.
to.
Within time. Okay, affidavit in opposition filed on behalf of respondent number 4 is taken on record. Copy given?
Yes.
Copy served.
Right now they have.
Copy served. Mr. Oshim Banerjee, learned advocate for the petitioner, seeks to file affidavit in reply. Let such affidavit in reply be filed within a period of 2 weeks. List this matter. The hearing er after 2 weeks. Paka dekhe jao. 2 weeks. ফাঁকা থেকে দেবে না?
PM. Lord, kindly fix it on 3 PM.
ppm
2 PM.
ppm
3 PM. I'm grateful to you.
ইয়ে দেবনাথ বাবু, এইটা আপনার কাছে রাখুন, আমি নামলে আমাকে দেবেন। এটা একটা না গতকালের একটা মামলা ছিল, ওইটাতে এটা ঝামেলা করছে না। কোথায় এটা বিশ্বব্রত? Where is Mr. Mullik? When he will conclude?
He's out of station, man.
When he's coming back?
But Malad 19th February, Malad
19th
February.
February.
Malad coming on Kolkata, man. He's out of station.
This is item numbers 53 onwards to 63. Numbers গুলো চেক করেছেন সব ঠিক আছে? Accommodation is sought for on behalf of Mr. Ishobroto Basu Mullik, learned advocate for respondent DPSC Hubli. Who is appearing for the state?
I am appearing for this. 62, item number 62.
62. Please, 19th এ পরের বলুন।
ডেট দিন
19th এর পরে বলুন ডেট। ডায়েরিটা দেখুন।
নাও না।
No, 19th March, no, 19th February.
19th February he is written.
Yes.
19th February পরে দেখুন, পরের উইকে
Yes, man.
ফার্স্ট উইক অফ মার্চে দেখুন না, 5th বা 5th, থার্সডে 5th, 5th এ ভর্তি, 6th 9th, 9th এ দেখো 9 10 কিন্তু গেছে, কিন্তু আজকে গেল জানি না কোনটা গেল কিন্তু ইলেভেন্থ 12th দাও 12th ये हियरिंग और 16th 14 के दिन 16 17 दिन না হবে না, 16 তারিখে 3টের সময় দিচ্ছি, পিকটা পেনশন করে নিয়ে এটা তো ও জাস্ট রিপ্লাই 16th
16th, my lord.
yes
March.
এবারে কত নম্বরে যাবো?
ফোন করে জেনে নাও না, থাকবে কি না, আবার নকেলটা মুশকিল আছে।
Item 8.
Who is for the petitioner? None appears on behalf of the petitioner. Yes.
I'm playing short crossover. Mr. Mitra is appearing now.
None appears on behalf of the petitioner. Yes.
I'm for the Madrasa board, but DME is the answering respondent.
This matter is
State,
related
state is the answering.
Lordship. State DME তো আজ ছিল এখনই কিছুক্ষণ আগে ছিল
State never appeared. All time none ever represented for complete service. None appears on behalf of the petitioner, nor any affidavit of service is filed in terms of order dated 6th November 2024. For ends of justice, the matter is adjourned. Same.
হ্যাঁ ছিল তো
Board is a party. Board is a party here.
Respondent 3. Respondent number 3, your lordship.
3, yes. 3 weeks for
Your lordship, the state is here. पर पिटिशनर नहीं है तुम्हारा नाम तो दिए दो बोले तो खाली तुम इंस्ट्रक्शन लेवे बोले दो
In this case, my lord,
take your breath take your breath
authority is the district director of minority affairs officer. So I have to take instruction first from him.
Lordship, this matter initially
the petitioner is not moving the application. Then there cannot be any
If you
direction.
move that time also, I will say this word, my lord.
Okay. Then let it appear after 3 weeks or
Okay.
2 weeks for a disco. 2 weeks for disclosure. After 2 weeks.
order দিন না না adjourn করেছি ঠিক আছে মামলা খারাপ করে না ঠিক
No, 10, 11, 12.
we are for the board, my lord.
I was appearing in item number 9. I was rushing from the ground floor. I am for the petitioner.
2 weeks. Where is the affidavit of service?
But everything is ready. We are waiting from the first half. As your
First
lordship
half.
was taking up the fixed matter.
Give your name.
I'm not
Learned advocate for the petitioner seeks accommodation to file affidavit of service in terms of order dated 6 November 2024.
lordship.
After 2 weeks, this will appear.
Yes,
ওটা একটু চেঞ্জ করো না
I'm getting
None appears on behalf of the petitioner. Nor any accommodation has been sought for on the last date, that is 4th February 2026. The petitioner also failed to appear. You are appearing this case?
Your lordship.
In view of the above, the writ petition being WPA 21874 of 2025 stands dismissed for default. All connected applications disposed of, interim order instant vacated. Urgent photostat certificate.
হয়ে গেল না এবার 14
Next.
State. यार चले गए
Board seeks to take proper instruction.
ডিএমই বলবেন
For the for the petition, the last location lordship passed in order.
Yes. So copy of this West Bengal affidavit of service.
আমি তো ঠিকই আছে কিছু অসুবিধা নেই ঠিক আছে
Where is the service upon the service commission?
Service, every service is there, man.
You have served the copy?
Yes, yes. On the same date, I served the copy.
After 4th February 2026?
No, on the same day, 4th
February 2026, where is that?
On 4th, when I served the notice.
এটা দিন যাচ্ছে অবশ্যই
দে
On the same day it has been served on the land who appeared.
What is your case?
For the prior formal of the transfer by your last annexer P8, which has been made by the land advocate. The last occasion, my lord, the Mr. Potik.
Mr. Dhar appeared. Is he there?
Yes, ma'am.
Mr. Dhar was in the other matter. Just tried to.
Last occasion, Mr. Dhar, my lord, the
Or the junior.
appeared. Madhumita Sarkar is the junior. My lord, their instruction, they have made the submission for taking the instruction.
Where is your application for transfer?
My lord, the last annexer P8, I prayed for consideration of the representation annexer AP8, which has been made by the landed advocate. Now the facts.
Presence of the commission will be necessary.
Paragraphs.
Presence
of the commission will be necessary.
Mr. Dhar was here in the last matter, and I remember your lordship that he had submitted that he required some instructions from the department.
Yes. That is so his presence is required.
If he is there, I don't know whether he is present or not. If you can get him, then the matter can be heard out, or I give a direction to you to serve a notice of intimating the next date. Shall I pass it over for some time?
Lord, the Mr. Dhar and the Mr. Madhurima already appeared on the last occasion. So I served the notice upon him.
Sir, I'm talking about today. If you can get hold of Mr. Dhar, I'm passing it over. Or else you give a notice and come back.
Or Lord say come back with the notice.
Okay.
Otherwise,
Mr. Mukteshwar Maiti, learned advocate for the petitioner, submits that the copy of the writ petition and its annexures have already been served upon learned advocate for the West Bengal Madrasa Service Commission. None appears for Madrasa Service Commission.
On teaching, non-teaching staff.
Learned advocate for the petitioner is directed to serve notice notice to learned advocate for Madrasa Service Commission intimating the next date of hearing. Next week. Next week.
Next week. Any. Any.
I beg to appear on behalf of the Madrasa Board. I'm for the petition. আমি accommodation আস্তে আস্তে Lordship had directed me to file the report. If your Lordship, I'm seeking an accommodation for filing such report. May be extended for 2 weeks, your Lordship. 2 weeks, বেনা খুব চাপে আছে না 2 weeks বলি না অত মামলা খারাপ করে কি লাভ আছে তাড়াতাড়ি হয়ে যাক না তোকে রিলিফ পা আমরা রিলিফ যদি না দিতে পারি তাহলে কি হবে
Nadim Sulaiman, learned advocate for the West Bengal Board of Madrasa Education, seeks extension of time to file the report. Let the report be filed within a period of 2 weeks. Advance copy of report be served upon learned advocate for the petitioner. 2 সপ্তাহ পর। 2 সপ্তাহ পর।
I'm led by Dr. Bari in this matter.
I'm for the state.
Report. Down. Your report, madam.
I have the report.
None appears for the petitioner.
Mr. Masud Karim is appearing. He is coming.
Copy has been given to him.
No, no. I have received it yesterday only.
Take it back, let him come.
No, no. Crossover channel.
Lord, Lord, in this matter, Mr. Othurup Banerjee is appearing for the petitioner. My lord, he is on his legs. If your lordship kindly pass it over for a moment. My lord.
Last occasion report to diya hoise na.
Which for the state in this matter?
The last occasion report was filed, I think so. Report filed hoise na.
Give a copy to him.
Copy to dijiye. Amar kache je ekta copy reported copy
Report you have filed. You have filed report.
Report dijiye.
It has been passed to us. Wait for some time.
No, to can. Doctor pass over for me.
Lord, a copy may be given to.
Report to na. This is the. No, but this is not a report. This is the statement of fact has given to me. This is not okay. The statement of fact. Report.
What is the prayer of the petitioner?
Lord, the petitioner's husband was an employee of the madrasa, my lord. Now, my lord, the petitioner is praying for the family pension payment order being PPO number. If your lordship kindly
Family
come.
pension.
Yes, my lord.
Being a second wife. Her name was not appear in the service book. Therefore, first wife dead. After death
Yes,
of
my lord.
first wife, it has not been paid to the second wife.
Why the second wife will get the pension?
Second wife name is not appear in the service book. No intimation has given to the employee. Only first wife was given. He was received the family pension.
Yes.
Hello?
At the time when the first wife was.
Yes, subject to not. But the issue remains, my lord. I have the wife is the admittedly second wife, and after the sad demise of the erstwhile wife, thereafter marriage occasion. The husband, this is husband duly
After death of the first wife, he again married.
Oh. Thereafter, my lord, the husband applied for the deceased husband applied for the change of the name of replace the name of the second wife, and that application was filed before the authority. Subsequently, my lord, the district inspector of schools, my lord, subsequent thereto, my lord, after filing the writ petition, this memo has been issued by the This memo has been issued by the district inspector of schools query for a certain documents. My lord, second page is the documents they have asked for. Now, my lord, what I am praying subject to a lordship's kind sanction, once they have asked for, if upon furnishing the same, let them consider the same. That will be the appropriate thing, my lord, as subject to a lordship's kind sanction, I believe. Yes.
Which is the representation?
My lord, initially, my lord,
on the basis of which this memo has
yes,
been.
yes, my lord, I'm just sending. Yes, my lord, that is at page 25. Page 25. The school authority has sent. Because, my lord, it is through school, my lord, it will go. My lord, it is high madrasa. My lord. Proposition is same.
Okay.
Thereafter, my lord, this particular memo has been issued, and in response with that, my lord, we will furnish everything if requires, my lord, then it can be disposed of. ও তোমার কাছে আছে তো?
দিয়েছে আমাকে ইনস্ট্রাকশন দিয়েছে তো দিয়ে দিই।
Yes.
File the affidavit of service.
Yes, my lord. This is the affidavit of service.
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition, the petitioner. Direction upon the respondent authorities to include the name of the petitioners in pension payment order being PPO number SEC/SEC/EMD/00053/2014 in place of Taslima Bibi,
My lord.
and to release the family pension in favor of the petitioner. The petitioner contains that the husband of the petitioner, namely Imdadul Haq Molla,
Expired
teacher in Jimajeria Welfare High Madrasa HS,
my lord.
who retired from service on 8 February 2014. At the time of retirement, the said Imdadul Haq, the concerned employee was married to one Taslima Bibi. The name of said Taslima Bibi was recorded in the pension payment order. Stop. The said Taslima Bibi expired on 29th March 2014.
My lord.
The concerned employee thereafter married the petitioner. What is the date of the marriage?
29th March 2015 at page 17, my lord.
29th March
2015.
বিয়ে করেছে
Date of solemnization of marriage
Thereafter,
issued by the
yes.
government of West Bengal, my lord, the certificate of Muslim marriage.
Thereafter on 18th July 2022, the petitioner submitted a letter before the concerned district inspector of schools seeking for necessary corrections and changes in the pension payment order. However, the same is still pending consideration. Hence this writ petition. Mr. So-and-so learned advocate appearing for the petitioner submits that a letter has been issued by the District Inspector of Schools, Secondary Education, Purva Mednipur on 4th December 2025, directing for submission of certain papers for grant of family pension in favor of the petitioner. He seeks that the matter be relegated to the District Inspector of Schools, AC Purva Mednipur, to decide the prayer of the petitioner for grant of family pension upon correction of details in the pension payment order. Mr. So-and-so learned advocate appearing for the state also concedes to such submissions. In view of the owner submission, petitioner submission, he files a copy of the letter dated 4th December 2025 under memo number 414-law of the District Inspector of School, Secondary Education, Purva Medinipur, which is taken on record. In view of the above submissions, the District Inspector of School, Secondary Education, Purva Medinipur, is directed to consider the prayer of the petitioner for correction of pension payment order and grant of family pension in her favor and dispose of the same upon notice to the petitioner within a period of 3 months from the date of submission of relevant documents as noted in the letter of the District Inspector of Schools dated 4th December 2025.
My lord.
Learned advocate for the petitioner is directed to communicate this order to the district. Respond number district is? Respond number such and such, District Inspector of Schools AC, Purvo Mendipur. Disposed of.
Respond number 2.
2. Disposed of.
I'm great.
Pass over document to? এটা কি আছে? এটা হয়ে যাক 18.
18, my lord. I am for the petitioner, my lord. Interest on gratuity matter. Single PPO.
State. State.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for interest. The petitioner contends that he was an assistant teacher of Sobol Singhpur High Madrasa, post Sobol Singhpur, District Hooghly. The petitioner retired from service on superannuation on 31st March 2024. The pension payment order was issued on which date?
21st April
21st April 25.
2025. The gratuity and arrear pension was disbursed on
3rd June 25.
which 3rd June
25.
2025. However, no interest was paid, hence this writ petition. Mr. So and so, learned advocate. Learned advocate for the state leaves the matter to the discretion of the court from the date following the date of retirement till the date of actual payment, 8% within a period of 8 weeks. Disposed of. Pass over to
8. 8, my lord. I am for the petition. Petitioner deposited a sum of rupees 7,78,000 just before the retirement, and my lord, petitioner is now want to refund the amount. The query of your lordship, earlier occasion, the petitioner retired on 31st March 2024, and the amount was deposited on, my lord, June 2023.
Okay. When was the order passed?
Pension payment order was issued on.
No. The order for refund was passed on which date?
Page 18, my lord. 6th June 2023. In the bottom, my lord.
No, this is date of deposit.
Yes.
But pursuant to which order this deposit has been made?
My lord, in these cases, what happened? School has calculated the amount, e-pension paper forwarded 1 year before the retirement, and when it was detected, then and then petitioner deposited.
Oh.
It has been countersigned by the DI assistant. Unless it is countersigned by the assistant inspector of schools, it cannot be deposited. And my lord, I am relying upon certain judgments also of this honorable court. Your lordship's order is there, but it was your lordship's query that since it was nearly 8-9 months, what now para 18 of the Rafiq Masih's judgment.
Para 18 clause 2.
Clause 2, 1 year.
Yes, that's why I am asking when the order was passed.
1 year before the e-pension paper ought to have been, my lord, generated. That is the rules. So, my lord, not before one year.
Cannot be.
Cannot be. That is, my lord, your lordship's query. My lord, I have corrected your lordship's.
Here is the Rafiq Kusi's judgment, my lord. এই যে পিছনের পাতাটা একটু স্টিপলার মেরে দিন। প্লে হবে।
Retired on which date?
Retirement on, my lord, March 2024. 31st March 2024.
So it is June, 9 months.
9 months. There are orders of also of this bench. Well, kindly have a look. It's nearly more than 1.5 years. But this honorable court has gone to Rafiq Musis, clause 3, Roman 3. If your lordship go to the Roman 3, if your lordship kindly have a look, that is another thing. Recovery of the employees when excess amount has been made for a period in excess of 5 years. If the calculation is made, my lord, on and from, my lord, 14 years, 15 years, then also, my lord, this
Impermissible.
it's not permissible. In the TR Chalan, your lordship, the reason is given, your lordship, if you find page 18, from 1st April 2008 to 31st May 2023. That is the reason. In other cases, well, court also interfered when 1 year also expired.
Okay. Ashun. By the present writ petition, the petitioner seeks for a refund of the amount of rupees 7,78,717 deposited by the petitioner towards overdrawn salary together with interest at the rate of 18% per annum from the date of retirement, date following the date of retirement till the date of actual payment. It will be from the date of
Deposition.
Date of deposit.
Deposition.
The petitioner contains that he was an assistant teacher of headmaster. He was headmaster of Horvonjo High Madrasa, Post Bajargaon, District Uttar Dinajpur. The petitioner retired from service on superannuation on 31st March 2024. Prior to his retirement, the petitioner was directed by the concerned district inspector of schools to refund the excess overdrawn salary of rupees 7,78,717 for the period 1st April 2008 to 31st May,
yes.
31st May 2023. In order to process the pension file. Pursuant thereto, the petitioner deposited the aforesaid amount on 6 June 2023. The direction for deposit of the aforesaid amount towards overdrawal of salary is impermissible in law. Being agreed by such action of the respondent authorities, the petitioner has preferred the present writ petition. Will be appearing?
My lord, regularize. Kindly regularize.
Okay.
Mohua Datta Bishwas.
Mr. Saurabh Mitro, learned advocate for the petitioner, submits that such direction to deposit the overdrawn salary is impermissible in law on two scores. Firstly, that the same has been directed within 1 year of retirement of the petitioner, and the period is more than 15 years.
Period of excess payment.
A period of excess payment is more than 15 years, comma, which is impermissible in law. To buttress his contention, he relies on the decision of Honorable Supreme Court passed in State of Punjab and others versus Rafiq Masi, whitewasher and others, reported in 2015, volume 4, SCC 334. First, second, এই দুটো ডিসিশন দিয়ে দেবেন, and decision of coordinate bench of this court এগুলো দিয়ে দেন WPS এইটা none appears on behalf of the state despite service, none appears. Mohammed Datta Bishwas, learned advocate, usually appears. Onar appears. She leaves the matter to the discretion of the court. The only issue which falls for consideration is whether the direction to deposit, direction of respondent number, district inspector of schools respond number, district inspector of schools AC Uttar Dinajpur, for refund of overdrawn salary is sustainable in law or not. Para, in order to examine the aforesaid issue, it would be profitable to reproduce paragraph number 18 of the decision of Honorable Supreme Court in Rafiq Masi Supra as here under. 18 number paragraph quote করবেন. Para, from the facts, it appears that the overdrawn salary amount of rupees 7,78,717 has been deposited by the petitioner within a period of 9 months of his retirement. The excess salary period as appearing from annexure P1 at page 18 is 1st April 2008 to 31st May 2023. Bearing in mind the proposition of the Honorable Supreme Court in Rafiq Masi Supra, the deposit as directed by respondent district inspector of schools AC Uttar Dinajpur is impermissible in the facts and circumstances of this case. Accordingly, direction to refund the same together with interest at the rate of 8% per annum ja thake from the date of deposit till the date of actual payment within a period of 12 weeks from date of communication of this order. Learned advocate for the petitioner direct disposed of.
Great.
Lordship. Lord, this matter relates
Go
to
through the report. See as a report.
challenging an order of so called.
But this give a copy to him.
Yes.
Thank you. Lord, one modest prayer, subject to kind sanction. Lord, when your lordship seeking it, my lord, affidavit from the side of respondent.
Not affidavit, only report.
They should come up before lordship a brief gist of the case along with the supported document by affidavit, so that we can get a
There
chance
was
to
no
controvert
direction-
the same.
There was
How-
no direction by your lordship to
Lord,
form
how
an
could I-
affidavit.
My lord, controvert this report? Neither it is a verified
Sir,
form,
it's-
it is a affidavit form.
It is signed by the department, my lord. Your lordship kindly see the original signature is with your lordship. There was a direction to file a report, not in the form of affidavit, my lord. If your lordship so desires, I will affirm it, but it is in the it was as per your lordship direction. It is a report. But on the last occasion, question my learned friend submitted before your lordship that only the show cause was sent to him via WhatsApp. I have given all the documents are attached with this report. The show cause along with all the documents related to the show cause were sent to him via email along with via registered post, which he returned as refused. If your lordship so sees the report, page 16, my lord. And on page 16 starts with the show cause notice. Then your lordship will find at page 19, that is the email communication. Then your lordship kindly comes to page 20. This is the dispatch from the department to Ruhul Amin, that is the petitioner, my lord, herein. On the very next page, page 21, it is the signature of the petitioner seen at the bottom, my lord. 10th October at 5 p.m. Page number 21, my lord. On the left, this is so he has made an allegation that it was not served upon him physically, only through WhatsApp. That he has also prayed in the writ petition, has made a prayer, specific prayer, that it was not properly served to him. It was served along with all the papers. I have stated that everything is stated in the report, my lord. If your lordship kindly takes the trouble to come to page 22. This is the photocopy of the envelope with the mark refused. Refuse is a good service. Your lordship knows that refuse is a good. It was served on him along with all the papers. Now another question cropped up on the last occasion, that the letter is addressed to head of institute, and the reply is given in the nomenclature superintendent. Head of the institute and superintendent both are same. There are two superintendents. One is the headmaster of the school. He is only called the superintendent. And the other is the hostel superintendent, who is attached to the hostel. And this superintendent, vis-a-vis the head of the institute, is also attached with the affairs of the hostel. This head of the institutes vis-a-vis superintendent works hand in hand with the hostel superintendent. They both are different individuals, but this head of the institute shares the same designation, superintendent, but the hostel superintendent. So the head of the institute and superintendent, the reply by the superintendent is the same person. On the last occasion, my learned friend said that the reply has been given by the superintendent, so he should not be served with a show cause. But the person is same. And if your lordship will find that from the Madrasa Act itself only. Your lordship kindly sees page 32, my lord. This is the West Bengal Board of Madrasa Education Act 1994. Your lordship kindly sees section 1D. This is the institution. Institution means a madrasa. Now he is a teacher, he is the headmaster of the madrasa. So he is the head of the institution, which means he is the head of the madrasa in the district he is attached to it. Now, your lordship kindly comes to page 35. Second point from the top, my lord. Head of the madrasa means and includes headmaster, headmistress, superintendent,
Which class? Teaching.
teaching,
Teaching category.
teaching category, my lord.
Headmaster.
Headmaster, head of the madrasa means and includes headmaster, headmistress, superintendent and teacher in charge. So head of the institute here, the petitioner can also be taken as the superintendent because he is the head of the institute, of the education, of the school. And the hostel superintendent is a different person. And these financial irregularities arose in the year financial year 2024-25. On the last occasion, my learned friend said, submitted that he made a representation to inquire about the budgetary allocation. If your lordship kindly sees the letter, 9 January 2025, it's at page 1, minor, is at and marked as annexure 1. 1. Your lordship kindly sees the letter 9 January 2025. I am reading, my lord. বিষয় 2025 সালে শিক্ষাবর্ষে মাদ্রাসা সংযুক্ত হস্টেলে নতুনভাবে আবাসিকগণের নাম গ্রহণ করিবার পক্ষে অনুমোদন প্রার্থনা এবং পরিচালন সংক্রান্ত নির্দেশিকা পত্রের আবেদন. Where is the single line asking for the budgetary allocation for the year 2025? My learned friend very much shouted on the last occasion that the budgetary allocation was not given to him, the entire slab was not provided to him, so he is not in a position to explain how the expenditure went wrong. This is the letter. It was shown by your lordship on the last occasion. So this is not a letter asking for budgetary allocation. This is for management of the hostel.
And the other.
Now the district magistrate's approval. Your lordship made an inquiry that whether the approval of the district magistrate was there while issuing the show cause. Your lordship kindly sees 36 page. This is a note sheet, my lord. There's an interdepartmental note sheet. Page 36, my lord.
Yes.
It is the first page speaks about the irregularities, my lord. Page 38 is the operative part, my lord. Your lordship kindly sees. On the left hand side, there is a mark DM, that is the district magistrate, who is writing, see in the report. This is the report from the DOMA, District Authority Minority Affairs. Financial and administrative irregularities have been noted by the inspecting team. A show cause notice may be issued to the authority running the hostel. A superintendent and hostel superintendent both run the hostel hand in hand. Based on reply, next action will be taken. Action taken report to be submitted by 15th of October 2025. On the very next line, ADMLR as directed, which means to proceed as directed by the district magistrate. On the basis of this, the show cause was issued, my lord, until 8th of October. And all the documents along with the show cause notice were sent to the petitioner, my lord, which was returned to the department as refused. বলেছি আমাকে বলতে দিন।
আচ্ছা,
my lord.
Should I answer? So for the 46 pages documents which has been submitted before lordship by learned friend, the question of law formulated the last occasion on 4th of February 2026, whereby your lordship asking whether the DOMA has the authority to issue any show cause or not. My lord, from the four corner of the 46 pages, I never find any relevant circulars, geo, or any instruction of the higher authority that the DOMA has the authority to issue a show cause notice upon the head teacher. I never find. First point. Well, this I'm harping on because My appointing authority is a separate man. My controlling officer DI is a separate man. DOMA, another person. Whether he has any authority or jurisdictions or any power, that has to be come up before Lordship from the side of the respondent. Yes, on the basis of that, I am empowered to issue show cause. My lord, last 2 days, my learned friend, one others, but he's not submitted. Today submitted. But from the reports, I never find any relevant provisions or any relevant page where from your Lordship can trust and your Lordship can meet it the question which has been formulated on the last occasion. I am not disturbing. Please, if you answer if there are no questions. First point. Second point, if your Lordship take trouble to the paragraph number 2. Your Lordship kindly come to the order dated 4 February 2026. Kindly just. Yes. My lord, show cause notice, my lord, just for pausing 1 minute, show cause notice was issued on 8 October 2025. Whereby directed me on the Friday, I am directed me to reply within 3 days. My lord, kindly take trouble to the writ petition and the show cause. Had there been an annexer in the show cause? If your Lordship kindly come to the page 22.
You have annexed the show cause.
Yes, my lord.
My lord, page 22.
Yes, I placed before your lordship.
Page 22, my original application.
Page 16 of my report, my lord.
Page 22 of my writ petition. My learned friend took the contention before Lordship that I have been served with the show cause, right? Along with all documents, but it has been earmarked as a refuse, very Lordship. Kindly come to the page 23, last portion of the letter. Had there been an annexer mark? Nothing. Kindly turn the page 24. The copy was endorsed to all the authority concerned for information taking necessary action. Any annexer has been earmarked? Well, my humble submission before Lordship, no. From the report, my learned friend citing an envelope where it has been refused. When the date has been earmarked on 10th. Notice was served on 8th.
No. Where is the date 10th?
My lord, I am showing your Lordship. My learned friend annex the envelope at page 16, perhaps, if I not, my lord, just
22.
22. Page 22. $16.10 and $17.10. Notice was issued upon me on 8. Asking me within 3 days answer. I have done it. Document reached to me on 17th. Kindly appreciate. My contention that the allegation which has been leveled against me, that document has not been furnished to me so that I can reply. On the contrary, on the basis of the complaint which I have received, you have straightway issued a show cause notice. Kindly give me a chance so that I can peruse the document. The document is coming on after expiry of the date and after submitting my answer. Well, if your Lordship take trouble to my page 22, where it has been directed me to reply within 3 days.
You have replied.
I have replied within time.
How do you reply without getting that?
Whatever the allegation level against me on the basis of what is the contention in the letter, I can give.
17th October, that date is immaterial right now because you have done your
Lordship. Now, my first argument before Lordship that the letter of show cause was not furnished any documents in the show cause letter. My learned friend justify their action that they have separately sent by speed post.
I can produce the records if your lordship so
I am disturbing my learned friend. I am not disturbing at the time of making submission. Kindly
will be required. I suppose you filed an affidavit in opposition, not report. file an opposition
My lord, as your lordship please, I will.
annexing all the documents. He has a grievance that the documents were not served.
My lord.
And also find out the rules, because he has also raised a point that whether the DOMA has a jurisdiction.
Your lordship kindly sees. Your lordship kindly sees my report. Your lordship kindly sees my report.
Now, second paragraph.
43 page.
Which one?
Page 43 of my report, my lord.
43.
43. Your lord, this is a memorandum, my lord, of 11 December 2015, my lord. May I read, my lord? The government of West Bengal in the Minority Affairs and Madrasa Education Department has been implementing various socio-economic development schemes for the minorities in the state, and the state government is committed to uplift people belonging to these minority communities through various means, especially by enhancement of educational opportunities and facilities like construction of minority student hostel for boys and girls, construction of educational infrastructure, etc. In the recent past, construction of a large number of minority student hostels have been taken up, and many of them are operational now. It is observed that the use of hostels by the student is always helpful for the interest of learning and inculcation of competitive spirit among themselves. It is felt to provide maintenance allowance for the students to make it more attractive. This will have far-reaching effect and help to address dropouts of the mostly first-generation learners of economically weak and downtrodden families. Now, your lordship kindly sees the objective. Pursuant to this view, a proposal for introduction of a new scheme for providing maintenance allowance to the students staying in madrasa and school attached hostels of the Minority Affairs and Madrasa Education Department was under active consideration of the government for some time past. After careful consideration and pursuant to the decision of the state government to implement such scheme, the undersigned is directed by the order of the governor to say that the scheme for providing maintenance and allowance to the students staying in madrasa school attached hostels to the Minority Affairs and Madrasa Education Department be implemented in accordance with the set of guidelines as follows. So the DOMA is giving the entire finance. He is setting up the hostel. Financial irregularities.
That is not the issue. Under the rule, if the DOMA has see, the rule has to be examined. If he has a power, then only can he may have administrative control, the financial power and all.
I showed to you, Lordship, there is an
Where
approved
is
district
what is
magistrate.
the existing rule by which a DOMA can issue a so-cause notice?
DOMA is giving the entire fund to the hostels. I can understand what is falling from your lordship, that how DOMA is authorized to give the show cause. If the DOMA is giving the entire fund, you lordship, bear with me for 1 minute. If DOMA is giving the entire fund for running of the hostel, and there are irregularities created by the hostel.
Sorry to, where
Mr. Karim, please. Yes.
The entire fund is being handled by the superintendent of the school as well as the hostel superintendent, and the irregularities are apparent. How the DOMA, I question myself, how the DOMA can be deprived of the right to issue the show cause along with all the documents? This is my question to myself. Your lordship kindly considers.
No.
There is an approval of the district magistrate as well.
The government hierarchy, there is a segregation of power.
Your lordship, whether
Suppose I tell you, suppose the land acquisition department is being controlled by ADMLR. Suppose, for reason. The rules does not permit the ADMLR to issue any so-cause notice to be issued by the district magistrate. As because the ADMLR is session of the land reforms, so he issues a so-cause notice as you have argued. So I want to examine the rule where from the DOMA has a power. Suppose he has the power of granting aid, financial aid or budgetary allocation, whatever. Now, whether he has the power, rule says that yes, he can also issue a so-cause notice. This is the originate.
Then I will.
In the origin, it has to be seen that whether he has a jurisdiction or not. Without going into the merit, if it hits the jurisdiction,
my lord,
then the so-cause notice itself is on the face of it becomes bad in.
But he has answered, given reply to the show cause. He waited for the time.
What will be the next step? Suppose for the worst, what will be? A discipline proceedings will be initiated.
And if
it is not
clean, he will
the so-cause notice is not accepted. Now, for the initiation, if it is bad in law, what will happen to the departmental proceedings?
This person is a headmaster of the school, my lord. He's running the hostel as well. Along with the
Understand. Superintendent is a superintendent of the institution.
as well as
He is
the
also with the assistance of the hostel superintendent, he is running
the financial.
So he cannot say that I do not have any knowledge of.
Yes,
I'm
my
not
lord.
onto it. He has raised a preliminary issue that whether the DOMA has a jurisdiction to
Jurisdiction.
issue that so-called notice.
But then I'll you will lordship.
What you do is you file your affidavit.
My lord.
That will be proper so that
My
he can also respond and pleadings be
My
complete
lord, my lord.
thereafter.
As your lordship.
The report filed by the state is taken on record. Miss Tulogna Bhattacharya, learned advocate for the state, submits that
আমাকে একটা কাগজ দেবেন?
the focus notice at the outset submits that the so-called notice was sent to the petitioner through post as well as through email. The petitioner has refused to accept the so-called notice. She also indicates that all the documents which were relevant to the so-called notice has also been sent along with the so-called notice. With the approval of the district magistrate, the district has issued the so-called notice. In reply, Mr. Masud Karim, learned advocate for the petitioner, submits that from the four corners of the report, there is no notification or rule indicated which gives power and authority to the DOMA to issue so-called notice. The date on the date of refusal shows 16th October 2025/17th October 2025, which is much after the period which was mentioned for filing the so-cause. Upon hearing the learned advocates, it appears to the court that the issues needs to be decided after exchange of affidavits. Accordingly, state respondent is directed to file affidavit in opposition to the writ petition within a period of 2 weeks.
And 2 weeks will be difficult because the officers are engaged in SIR. They are not being able to come to the court, my lord. Your lordship gives me some more time. I am ready with the papers, but the
SIR
officers...
is over by now, I suppose.
No, no, it has been extended, my lord. 28th.
SIR was completed, final
No,
decision is
yesterday.
28.
20th.
28th.
28th February is the last date for publication, the final
4
total
weeks.
date.
4 weeks.
Bolna.
After 4 weeks. 4 weeks. Within 4 weeks, reply. 1 week reply. After 5 weeks, it list karo under the heading. Date dekun. Hearing a date now.
One modest prayer, subject to kind sanction. But in the meantime, no coercive action.
In the meantime, you order to extend. In the meantime, no coercive has been taken against the petition.
Disposal of, because your lordship already fixed hearing and it.
Till the next date.
Till the next date.
No, till the next.
So the state responded, madam, here. Last occasion, there was a direction, madam, to take instruction, madam. So, madam, we are ready to pay. We are ready to pay. This is my instruction. We are ready to pay. Just submit the relevant documents before the authority.
I have already submitted.
As per the instruction, I'm telling you. Whenever you submit it.
Arrear of salary from which period?
That salary mailer from my lord.
Area salary.
And they get it. 22, page 22. From 1/7/13 to 30/11/18.
Everything has been calculated, madam, in my instruction.
Does you get it? Fixation was met. But area has been
13 to 30th November.
30th November. And while I am paying my lord interest, I am entitled to have it. It is my lord the monetary gain case, Supreme Court judgment. It is not punishment.
By the present writ petition, the petitioner seeks direction upon the responding authorities to release arrear of salary from amounting to rupees 1,09,709 together with interest at the rate of 10% per annum in favor of the petitioner.
Hello.
The petitioner contends that he Suleiman is appearing for the
madrasa board.
What is your submission? You are not the answering.
I'm not acting in submission because I'm not standing in the.
Is an assistant teacher of Kontai Rahmania High Madrasa within bracket HS post Darua PS Kontai district Purbo Medinipur. The petitioner is a teacher in the subject of biology.
Subject of bioscience. Subject of
Bioscience, not biology.
Same mind.
Bioscience.
Bioscience.
The petitioner joined, when did he join? 16 November.
My lord. 2007.
16 November 2007.
My lord.
During that time, my lord, he has no training qualification. He completed
The
training qualification.
petitioner joined on such and such without as an untrained teacher. Subsequent thereto, the petitioner obtained a Bachelor of Education degree through ODL mode from Netaji Subhas Open University in the month of March 2015. Paragraph in terms of government notification, government circular being number 759 such and such of the School Education Department, Secondary Branch, the increment of untrained assistant teacher was allowed up to year 2012.
Thereafter, it was extended next, page 20.
একবার বলে দিল ভাই থার্ড প্যারাগ্রাফ বললেই তো হয়ে যাবে।
ডেটাটা কোথায় গেল? Where is the letter? Your
that is my page 20. That is first notification up to 2012. Thereafter, it's extended to 2017. Page
As the
20.
petitioner did not had the B.Ed qualification, his increment was stopped with effect from 1st July 2013. Subsequent thereto, the School Education Department has granted one-time relaxation to the petitioner to all untrained candidates to complete B.Ed. In terms of the government circular, petitioner completed B.Ed within the stipulated period. However, his annual increment was stopped for the period from 1st July 2013 to 30th November 2018. On 20th March 2018, the petitioner made a representation before the secretary of the said madrasa, which was forwarded to the Additional District Inspector of Schools AC on 16th January 2019. However, the same has not yet been released. Stop, hence this writ petition. report statement of facts filed by the district inspector of schools. Opore diye deben. Purbo Mednipur, what is the date? 5th February 2026 is taken on record. Learned advocate for the state at the very outset submits that the concerned authority, namely the district inspector, who will sanction this?
That is my district inspector.
Yeah, madam.
The district
Yeah,
inspector schools, secondary education, Purvo Mednipur, would sanction the claim of the petitioner as prayed for. Subject to production of which documents you require?
My lord, the mention over there.
Huh?
Mark sheet of certificate of birth needed and arrested copy of the attendance roll of the previous.
We have already complied.
Very well.
Subject to compliance of subject
your
to
lordship
production
can
of
note it.
relevant documents.
Yes.
Learned advocate for the para, learned advocate for the petitioner submits that the relevant documents have already been produced. Huh? Accordingly, in view of such submissions, district inspector of schools respond number
Respondent number
is directed to
that is my
release the
C.
area of claim
This one C
of the petitioners amounting to rupees 1,09,709 subject to production of relevant documents if not already produced, together with interest at the rate of 8% per annum from the due date till the date of actual payment within a period of 12 weeks from date of communication of this order.
Deep learning. হ্যাঁ কি করছে দেখুন কি অবস্থা পেন দিয়েছে কি করছে
চলো তাহলে জল খাই আর গিয়ে
My lord, may I mention, may please, my lord. My lord, may I mention a matter, my lord.
No.
My lord, it was.
My lord.
Sorry, sir.
Afternoon.
Okay. Sorry.